Good afternoon, sir.
Hi, good afternoon. So can you hear me?
Yes, sir.
Okay. So this is a break time.
No, sir, we're waiting for the participants to join. We start in about 15 minutes.
Okay. May I try to upload my presentation file?
Yes, sir. So just beside your stop video, you'll see a share button. When you click
Share,
on
yeah,
that,
share.
you'll be able to see a lot of things that
Okay,
maybe that you want to share.
yeah, I
Yes.
will try. Mm. Oh, okay. I think there are two ways, but anyway.
No, so just beside stop video, you should see a share button. When you click on that share button, you'll be able to see you can upload files, you can share a particular window that you want to share. For instance, if you want to share a PowerPoint, you'll be able to share that. Or if you want to share an Excel sheet, you'll see the Excel button. So all the windows that are open, you'll be able to see that. And if you click on the particular window that you want to share, when you click on that, we'll be able to see that.
Content share, right?
Uh,
Content share
yes,
or
yes, yes.
content
Um,
share.
yes, content to share.
And then what is the next step?
You will see the windows that are open on your screen. For suppose you'll be able to see Cisco WebEx, or if there's a PowerPoint presentation that you've opened, you'll be able to see that. So
Windows,
when you,
this
okay,
one?
yes, and yes, I can see something. It's a lag.
It is not shared, I think.
I'm able to see something, but it's just a gray screen. Maybe it will take a bit of a second to come back. So what exactly are you sharing? May I know?
Can you see this file? Can you see? No? The
No,
presentation file?
no, I see a gray screen. Maybe you can try it again. Click on share and in the share content part, click on the window that you want to share.
Mm, Let me try another option.
Okay, now I see your Cisco WebEx screen. Yes.
Okay. Oh, is it that one? Can you see?
I see the Cisco WebEx screen. So you need to open your file, then I'll be able to see that maybe.
Let me try another option. This one.
Yes, I can see something, but it's WebEx meeting, web tour. I see again a WebEx page.
Can you see the front page of economic analysis of information security? Can you see? No?
No, that I don't see. I see something else. So even if you just click on the screen button when you share in the share, just click on the share button, and in that, if you click the screen also and press share, then also we'll be able to see your screen.
Okay, I will try from the beginning again. Share. So if I click share, I have three options: content, or web browser, or my meeting window. So which one?
So do you have the file that you want to share open in your in the background? Open it and
In the
minimize the
background, yeah,
file.
in the background,
Yes.
my file is opened.
Okay. So in the share, when you click the share part, in the share content, you should see that file.
So content. I have to click content, right? Content option.
Share content, in that
Yeah.
you should see the file. May I know the file name, or is it a PowerPoint presentation or is it a PDF?
It's PDF, but yeah, just a minute.
Yeah, it's a
Okay.
PDF. Are you sharing, I mean, are you using a Windows browser? I mean, a
Windows browser, yeah.
a Windows PC or a MacBook?
Hmm?
Are you using a MacBook or a Windows PC?
Windows PC.
Okay, so if you're using a Windows PC, you should see the PDF part, Adobe or something, in which that file is open in the share content part. Just click on share in this meeting. Click on share.
Mm. So content sharing is opened now. Then I have three options: a window, or file, or whiteboard. Which one?
Uh,
Huh?
window. Click
Window.
on window. Yes,
Window.
and
Okay.
okay. And in window, you should see some options like Cisco WebEx meeting or something else that is open in the background.
Okay. So okay, I will check. Click this one. Then
We see, yes, we see economic analysis of
okay.
information. Yes, if
Oh,
you
that's it.
maximize the file,
Yeah. Sure.
we'll be able to see it for. Yes, sir, we see
Okay.
it now. Okay.
This is my first time to use Cisco. I o- I only use the Zoom, so I'm very.
It's almost very similar, sir, but we are able to see it now. So so that is fixed.
So I learned.
Uh, so we're waiting for the participants to join. We are joined by 8 participants. So almost about 60 people, 30 to 60 people join us. So let's just wait for a couple of more minutes and then we can begin your session, sir. It's a pleasure having you today.
So, can I start, or we have to wait a little bit more?
Sir, we have very few participants right now. So I would suggest we wait for a few minutes and
Okay,
then we
few
can
minutes.
begin the
Okay.
session.
Okay.
Okay, thank you, sir. A very good afternoon once again to you, sir. Now we are ready to commence with your session. I request my moderator, Khushi, to please introduce her so that we can then commence the session.
Good afternoon to everyone, especially to all our resource persons, our panelists, and all the attendees. On behalf of the GNLU Center for Law and Economics, I would like to welcome all of you to day 5 of the second GNLU workshop on law and economics. To start us off today, we have Professor Jong Yu Kim, a professor in the Department of Economics at Kyunghee University from Seoul, South Korea. Sir has immense experience in research in areas such as business and economics, social welfare. Very recently, the recipient of AdStar's New and Young Stars Award of 2020, Professor is here today to talk about an economic analysis of information security and liability. We welcome you, sir, and please go ahead. Thank you.
Okay, thank you. Thank you for the nice introduction. It's a really great honor to be invited to your excellent conference. Okay, the topic today I want to talk about is the information security. So let me briefly describe why this market is important. I think this is quite a new area to most of the economists. Okay, first of all, this market, the security market, has been steadily and rapidly growing these days. So for example, US consumers' share of online transactions is this. So 14% 2 years ago, and 16% last year, and 21% in 2020. And there are lots of fintech companies, including PayPal, Stripe, Amazon, Square. I think most of you had already experienced of using one of them. So I think there are lots of legal issues, including liability issue, economic issues, regulatory issues involved with this security industry. So let's think about this market. Let's think about online payment, online transactions. For almost all electronic transactions, self-identification is required, right? That means security is almost a necessary good these days, right? So it is required for almost any transactions. So anyone needs it. Without it, we cannot make electronic transactions. So that's the reality. That means we can think of security as a commodity. Okay. Then what kind of characteristics are required for security technology, security commodity? I think two characteristics are most important. One is safety, right? Safety, and the other is convenience, right? Safety and convenience. But unfortunately, there is a trade-off between the two. That means if security level is high, no risk, but very inconvenient to consumers. On the other hand, if the security level is low, then it could be very convenient, but too risky, right? So here is a dilemma for firms to determine the security level. And there could be conflict of interest between firms and consumers and the government. So let me take an example of a possible conflict of interest that motivated this research. My Darling from a Star. That's a very famous Korean drama that was very popular in several years ago. And actually, that drama was popular not only in Korea, but also in East Asia. So lots of Chinese fans rushed to order the coat that the main character in the drama was wearing, so-called Cheonsong이 coat, right? But unfortunately, most of them failed because the Korean online shopping mall usually requires the national electronic identification that is not issued to foreigners. Okay, that is the one example of too high security level, too strict security level to consumers. Anyway, one important observation from this example is that consumers take a great deal of efforts for security checking, right? This is really annoying procedure to consumers, really costly to consumers. So I think the consumer's cost, the cost that consumers bear, should be taken seriously. But unfortunately, no previous studies paid enough attention to the consumer cost for security checking. That's the main motivation of this paper. So here I address two issues. The first issue is a security issue. As I said, there is a conflict between seller and buyer, right? So consumers' effort of security checking generates huge positive externality to firms, even though it is costly to buyers, right? There's a conflict between buyers and firms. Then what is the optimal level of security level? So what is the socially optimal level of security? That is the first issue that I address in this paper. And the second issue is the liability. That means if something goes wrong with online payment, then who should be liable for the losses? If the firm fully compensates for the consumer's loss, it is a strict liability rule. But if the firms does not compensate for the losses, it corresponds to no liability rule. Of course, there are lots of intermediate liability rules. Then, what is the socially optimal liability rule in this security market? That is the second issue addressed in this paper. So my main intuition is the following. As I said, consumers' efforts for security checking has a huge positive externality to firms, right? So if the security level is chosen in favor of consumers, then definitely there will be under investment on security, right? Because the consumers do not care about the positive externality generated to the firms. On the other hand, if the security level is chosen in favor of firms, in that case, there will be over investment on security. Then the important question is whether the security level security is underestimated, under invested, or over invested, or it could be socially optimal. Here's the main result. If the market is monopolist, so I have several, roughly 3 results. So first, if the market is a monopoly, then security level is socially optimal. That means we don't need regulation, right? But if the markets are competitive, then the two firms, for example, two firms compete for consumers, then the security level is too low. That means we need regulation. Okay, that's one result. And this result is quite surprising, right? Because usually monopoly market should be regulated and competitive market did not be regulated. That's the conventional lesson that we learned from the traditional economics. But here, the result is reversed, right? The result is reversed. In the monopoly case, no need to regulate. And in the comparative competition case, we need some regulation. So the traditional result is reversed. And also, a more surprising result is that if the firms do not know the consumer's type, so if there is some kind of incomplete information, then the result is again reversed. That means in that case, in the incomplete information situation, monopoly market should be regulated and competitive market did not be regulated. Okay, so that's the main result of this paper. And there are several, actually, there are several related papers, but I better focus on one closely related paper by Creti and Verdier. That paper is quite similar to this paper in the sense that it addresses the security issue and the liability issue. Okay, it's very similar setup. Not similar setup, but anyway, the issue itself is very similar. But the main difference between the two papers is that in their model, consumers do not bear any authentication cost for transactions. Even though now, as I said, the consumer's cost is the unique feature of this of my model. So that difference, that difference leads to contrasted results that it is socially optimal for sellers to bear all the losses. In other words, for the sellers to use strict liability in their model, whereas the strict liability rule can never be socially optimal in our model. So as you can guess, the main difference comes from the assumption that the consumer's cost in our model, in their model, there is no cost. There is no cost for on the side of the consumer. That's a main difference. And there are other related literature, for example, Yoon and John, and other papers, but most of them focus on only one issue. So liability issue, either liability issue or security issue. Okay, but my paper and this paper, Kreti and Verdier, I think those two papers are the only papers that address the two issues simultaneously: security issue and the liability issue. Okay, let me briefly describe the model. This is a quite a simple model. This is actually this is a benchmark model, basic model. So there is one seller and homogeneous consumers, or equivalently a representative consumer. So one seller and one buyer. And the C is the consumer's effort cost for security checking. And the C determines the accident probability. If the consumers take more efforts, then the accident probability will be lower, right? Okay, and the V's are benefits from the transaction if the transaction succeeds. And the R is the losses, total losses, if the transaction fails. Okay, and the rho is the liability. Rho is the seller's liability, seller's share of liability. So that means if rho is 1, then it is a strict liability because the firms fully compensate for the losses. But if rho is 0, that means no liability. And the K is the seller's cost of installing and maintaining a security system. Now, the utility functions are given as follows. The seller's utility function is this, and the buyer's utility function like this. Actually, these utility functions might be very familiar to most of you who majoring in law and economics, because it is a very typical setup in the contract law or tort law. So, for example, in the contract law, if there is a contract between seller and buyer, and then we can interpret the P as a probability of contract breach, right? Then very similar setup as the contract case, but the important difference is that here, so C in the contract case, C is interpreted as the accident preventing effort, right? But here, main difference is that in this case, the optimizer is not the effort taker. It means that this C is usually taken by the buyer, but the C is not a choice variable of the buyer, right? The seller choose the security level. In other words, the seller forces the buyer to choose some particular level of C. That is the security case. But in the contract case, it is not. In the contract case, the buyer choose his own effort level, and actually he does take that effort. So optimizer and the actual effort taker are the same in the case of contract or tort. But in the security case, it is not. The optimizer is the seller and the effort taker is the buyer. That's also another unique feature of this model. Okay, now first we consider the monopoly case. The monopoly case, as we saw, as we can see from these two utility functions, we can see that the seller's favorite security level is higher than the consumer's favorite security level, because consumer has to care about his own effort level for security checking. Due to this extra term, buyer usually prefer lower level of security than the seller. Okay, that means the socially optimal security level is in between, right? Now, then can the firm implement the social optimum? The answer can be yes or no. If the firm, if the monopoly firm can choose the security level and liability share, then the answer is yes. That is the proposition 2. That is the proposition 2. So this proposition means that the firm can implement the socially optimal security level by choosing the liability share correctly, right? So how can it be possible? How can it be possible? The main intuition is that in this model, consumers' participation constraint must be always binding. In other words, consumers' surplus must be always zero. That means social welfare, right? Because that means the social welfare is the same as the monopoly firm's profit. In other words, that means private optimum of the monopolist must be the same as the social optimum. That's the main intuition. So in this case, what is the role of the liability share role? The liability share has plays the role of internalizing the externality, kind of price. Okay, so anyway, in the monopoly case, if the monopolist can choose security level and liability share, then always social optimum can be achieved. So we don't need any regulation. And how about in the competition case? Competition case is a little bit more tricky. So in this case, several firms, for example, two firms compete for more consumers by choosing security level, right? So consumers want more convenient payment system. So the like the standard Bertrand price competition, the two firms keep undercutting the rival security level competitively to attract more consumers. Okay, so if the two firms compete only by security level, usually the resulting equilibrium level is the consumer's favorite. That is the proposition 3, this one. So the equilibrium security level must be equal to the buyer's favorite. It is much lower than the social optimum, right? Social optimum. But if they compete by security level and liability share, then they both choose rho equal 1. That means strict liability, right? Why? Because to give consumers the highest consumer surplus, so they want to compensate more, right? That's the strict liability. Okay, so the idea is quite simple. So the competing firms try to give consumers the highest utility, so they fully compensate by choosing rho equal to 1. Then they choose the security level that gives the highest utility given the strict liability rule. Okay, that is the these two. That is these two. Then can we achieve the social optimum? Unfortunately, the answer is no. So in this case, there is no value of rho that can implement social optimum, right? So in that sense, we don't need regulation. Even if the government regulate the level of liability share, we cannot achieve the social optimum at any rate, right? But we can compare the outcome. So the relative the regulation cannot achieve the social optimum, but regulating the liability share to 0 is better than any other feasible outcomes. We can see that from a figure. So here C star is the social optimum, socially optimal security level, and this security level is the best security level under no liability rule, and this security level is the best under strict liability rule. So here So for any row, the equilibrium security levels are much lower than social optimum, right? So in that sense, regulation cannot achieve the social optimum. But this is better. The no liability rule is better than strict liability rule in the sense that this security level is closer to the social optimum than the security level under strict liability rule. So why is that? Roughly speaking, that's because if the liability share is increasing, then the consumers prefer lower security level. That's the main driving force for the result. So that I can give you some intuition behind this result, but due to the lack of time, if I have time, I will revisit this part. Okay. And this is the most interesting part, I think. So far, we just assume that all consumers are homogeneous, right? All consumers are homogeneous. But in fact, in reality, all consumers are not the same, right? Not the same. For some consumers, it is relatively easy to use security system, but for other consumers, like old people like me, it is much more costly to use security technology. And actually, a large proportion of old people just give up the online transactions simply because it is too inconvenient for them, right? So here is a secret to serve both types of consumers. For example, suppose the firm offers two kinds of menus. The firm can offer high security, but instead high compensation, or low security, but low compensation. Okay. Then, if you have if everybody has the two options, then what do they choose? Probably old people will prefer low security and low compensation. But young people who are very familiar with IT technology will prefer high security and high liability, high compensation, right? That's the main idea. So if the security choices are made in two tiers like this, then I think the security technology can please both types of consumers, IT experts and IT novice. So okay, so let me explain this model. So we assume heterogeneous consumers. The consumers can be one of the two types, either IT expert called high quality type, or IT novice, the low quality type. Okay, so there are two types of consumers. And consumers know their own type, but the firm does not know. They only know the probability that a consumer is a high type. Okay, so there is a incomplete information. So the information about the consumer's type is just private. The firms do not know. And S is a security level. And W is the consumer's cost. As I said, consumer's cost. And the consumer's cost for self-identification depends on the security level S and the consumer's type, theta. If theta is high, so if the consumer is a high type, then the cost is higher. And if he's a low, if the cost is low, if theta is low, if he's a low type, then the cost is low. Then we have a typical mechanism problem. So in general, under incomplete information, we get the second best solution, which is different from the first best solution that we can obtain under information case, right? So this problem is the optimization. This problem is the under the problem that the monopolist should serve in the complete information case, right? So in the complete information case, the monopolist maximize the utility, the seller's utility, subject to this constraint, participation constraint, or individual rationality condition. Okay, that is the so by solving this problem, we can get the first best solution. But but under incomplete information case, we get the second best solution. In that case, the optimization problem is a little bit more complicated. In that case, the seller maximize the expected utility subject to 4 constraints. So 2 individual rationality condition and 2 incentive compatibility condition, so that one type cannot imitate the other type. Okay. Then we can the second best solution can be characterized by the following diagram. So in this diagram, the black bullets, they are the first best solution, right? So if the two, this is the first best solution, but on the incomplete information case, the second best solutions are the red bullets like this. So what's the in the under incomplete information case, the monopolist must distort one of the 2 menus. In this case, the menu to the low type should be distorted downward. Why? Because distorted downward so that the high quality type cannot imitate this option, right? So here, under incomplete information situation, the monopolist offers very low security level and very low compensation. Then the high quality type cannot imitate that option because it just give him a very low compensation, right? So they just prefer to choose the high type, this pair, but the low type consumers cannot imitate the high type menu because it requires too high security level, so they cannot choose that. Okay, so this is the second best solution. Then by comparing the first best solution and the second best solution, we can see that in this case, there is some need to regulate the security level, right? So in the monopoly case, under incomplete information situation, if the market is monopoly, then that market should be regulated. But if the market is competitive, then we can get the first best solution even in the incomplete information case. So this result is a little bit similar to Rothschild-Stiglitz result, but a little bit different in the sense that a separating equilibrium always exists in this case. But in the Rothschild-Stiglitz insurance market result is that a separating equilibrium may not exist if it can exist only if the lambda some parameter must satisfy some condition or something like that. But in this case, first best separating equilibrium always exists. So that's a slight difference from the Rothschild-Stiglitz result. So this is the main result. So let me conclude this paper shortly. As the volume of electric transactions keep growing, the security technology and the economic principle behind it becomes more and more important. And we have different implications on regulation depending on the market structure or choice variables or information structure, right? So if the in the complete information case, if the market is monopoly, there's no need to regulate. But in the competitive market, if the market is competitive, we need the regulation. But in the incomplete information case, the result is reversed, completely the opposite. Okay, so for regulation, we need more careful economic analysis for the security market. Okay, that's it. Any question? No question?
Can I ask one question?
Yeah, sure.
Like going through your conclusion,
Conclusion.
I don't know. It's how to fix liability with regard to information per se, which are there in the public account, maybe private account also, like Gmail, Facebook, Twitter. How the liability can fix? I'm still not getting, like, if you can recall what happened in US with regard to the election time of something, Twitter and Facebook involvement on some specific party, yeah, something not going against the ethics of the social media. So I don't know how far liability can be fixed in context of the securities.
Yeah,
And I don't know whether there is uh, uh, the punishment. Yeah, there is a deterrent, a signal given to the breacher. Yeah, not, that is also a big question. I don't know. Maybe in your country may be different, but
yeah, different. Yeah.
if you see worldwide, we find that there is no a clear demarcation uh, of the making sure that data are protected and they are not misused by anyone. So if you can just give your view from your research, if it's possible.
Yeah, in reality, it's really complicated institutional problem, and actually, most of the various countries have various institutions, so I cannot say a uniform answer, and we can apply a uniform principle to that. But in Korea, usually that issue is resolved by the insurance. Here, I don't assume the insurance market, but usually it is mandatory. Actually, the government that I as far as as far as I know, it is resolved. That is the law. It is resolved by the insurance companies, something like that. So yeah, but in this paper, I didn't assume the insurance market. So I think there are, if without insurance, we could have another solution. And I think this analysis can give some hint about which liability rule is better in some particular situation or something like that. So we can think about uh, the issue in this model. But I think that's very important issue. Yeah.
Thank you, Professor Jin Kyo Kim. Thank you very much.
Professor GNLU Kim, good afternoon. I'm Professor Nagar, head of the Center for Law and Economics at Gujarat National Law University. And I just want to, thank you. The center is very honored to have made this association with you. So thank you very much about that. Now coming to the paper, sir, would it be correct to state that, you said monopoly, in a monopoly, given the information, situation defined, there would be no need for regulation. So would that be an impossibility in the real world?
Which is impossible?
a monopoly with full information, which would not need to be regulated. Would that be an impossibility?
Oh,
And competitive market, with information asymmetry would need regulation.
oh, the monopoly case. I don't have a good example, but anyway, in the monopoly case, and if there is no information problem, then no need to regulate, right? The theoretical result is that the government does not need regulate, because the monopoly firm can, because basically there is no conflict of interest between the monopoly firm and government. So government doesn't need to regulate, because the firm can voluntarily pursue for the social optimum. Yeah. So you're saying that it is unrealistic, or?
So I was saying that would that be just at the theoretical context, or would it have some example or some application wherein you are a monopoly with full information, and therefore you do not need regulations, which means that you're using optimal security levels and so on and so forth.
I don't have a good example in mind, just theoretically, but in reality.
Professor, we actually, me and Dr. Thakkar were thinking of, asking you for some time and then, have some discussion on this paper and multiple other possibilities. At that point of time, I'm sure we'll interact. If that is all right with you, Professor.
Okay.
Yes, so we will interact.
Thank you, Professor Lincoln. Subi, over to you.
Sorry?
Proceed.
Thank you, sir. Thank you for your session.
Okay. Okay.
We are joined by Anil Suraj sir as well.
Okay. Thank you.
Thank you, sir.
Mhm.
Good afternoon, sir. I've given you the sharing rights. You can try sharing your screen. I mean, maybe we will be able to see it.
Yeah. Good afternoon. I must take this opportunity to thank Professor Kim. I enjoyed your session. I think it's a good way to continue on that theme itself. So should we begin right away? Should we? Is that okay?
So we have 4 minutes to your session. Meanwhile, let's just check whether your screen sharing is working or not, whether we are able to see your PPT.
Yeah. Yeah. Is this?
Yes. Yes,
Okay.
we are able to see it, sir.
Okay.
So I request Khushi to please introduce sir, and then we can commence the session.
Good afternoon, sir. So today, for our second session, we have Professor Anil Suraj, who is currently a professor of practice in public policy at Indian Institute of Management, Bangalore. Prior to joining IIM, Professor Suraj was a research fellow at the National Judicial Academy in India, where he coordinated training courses for various judges on topics such as economic analysis of law and adjudication of economics law, with specific focus on intellectual property rights. Since his graduation, he has been involved in different national and international research projects And the range of research themes that he has pursued includes access to justice for poor and disadvantaged, public contract law, judicial impact assessment models, urban governance, and anti dumping policies in India and EU. It is quite an honor today to have Sir here today. He will be talking He'll be talking about policy, law, and economics of data protection. Thank you so much, sir, for being here today.
Thank you. And I must also thank Professor Hitesh Thakkar. I think thank you for considering me to be part of this excellent, timely program. I also would like to thank Professor Ranita Nagar. I think we've interacted on this theme of law and economics. And I would like to believe that we are continuing this collective initiative. And I think this program would add further strength to the kind of, if I may say, at some level, an Indian thought on law and economics of various themes that I'm sure all of you have heard speakers for the last 3 or 4 days. And my attempt would be to make a very small contribution, because I really don't have that kind of scholarship that Professor Kim spoke about in the previous session. But I do have some views, and if I may say, drawn from my interactions with the industry, the professionals, students, especially of management. And to that extent, I think there is a very clear need to look at, or if I may say, relook at policy, law, and economics when we speak about data protection. I do realize from the schedule that you've had the wonderful sessions from many speakers across firmament of disciplines. And they have also perhaps spoken about related themes. But pardon me if part of this could be some kind of a repetition, but I would like to emphasize that data protection, especially in the Indian legal or in the Indian economy, is of a very particular or of a very unique, challenging aspect, right? So that would be the context. Just to clarify, I mean, while the time given to me is at 3:50, I would like to perhaps, I think it's exactly 3 now. So I would perhaps take about half an hour, 30 to at the most 35 minutes to lay out what is it that I believe is the contours of policy, law, and economics of data protection, especially in the, I mean, or rather only in the Indian context I'm talking about. Questions may be relevant even for, let's say, European Union, or even for the let's say, the US economy. But having said that, I would like to um, encourage people, if you have any thoughts to share, feel free to put it up on the chat, or even if you unmute and kind of want to raise a question, feel free, because I think I suppose many of you are researchers, many of you are looking at this topic, or all the topics for that matter, in a manner as to see possibilities of undertaking various kinds of studies and pursuing projects. So I would love to hear from all of you as well as to what could be your concerns or questions, or even experiences with regard to aspects I will be talking about. All right, with that, let me quickly just lay down what is exactly the aspect I would like to look at. A quick overview. First and foremost, I do want to spend about maybe 4 to 5 minutes on telling you that the word data has assumed multiple, in fact, varied, multiple, uh, in fact, perhaps a better word would be several dimensions, and dimensions which are only growing, right? Which are only becoming more and more complex in terms of the source, the scope, the origin, the authenticity, the accuracy, right? These are all dimensions that need to be looked at. These are all dimensions that need to be uh, kind of understood in a very uh, in a very clear, concise, and unambiguous manner. Right? I think that's very important. And data, we usually take decisions based on data. But then, if data itself is subject to so many different dimensions, several dimensions, then I think we need to be very careful about what should be the manner in which we understand. But coming back to our focus for this part of our discussion, when we look at policy or law or economics of data, one of the first questions to ask is, what do we actually mean by data, right? So that is something that we will take a look at and try and understand what are these different dimensions. And again, we could be very quickly or very soon adding to these dimensions based on emerging experiences. Very next point, and I don't think I need to kind of emphasize on that, is that we need to bring in some element of data protection. Now, whatever data that we are looking at in the first part, then the question to ask is, how do we protect this kind of data? Now, naturally, I'm sure all of us are familiar with these terms. In a very personal context, we look at consent. In a very enterprise level aspect, we look at compliance. And I think what is related is about the costs, right? The cost associated with uh, the entire architecture of data and data management is riddled with a lot of costs associated with protection, associated with compliance, associated with securing and maintaining consent. So I think we need to factor this in. We need to, first of all, have a good way of valuation. We need to, and for valuation, as I'm sure many of you are experts on economics, you will be very well aware and perhaps even kind of, skilled in being able to identifying heads of what could these costs be. And to that extent, this is now emerging as a very, very critical business cost. Right, the business cost of protecting data is, in fact, I could very well use the term prohibitive, and that is a worry. That is indeed not a good sign, especially for an emerging economy like India. I think the cost of doing business must be uh, uh, very kind of manageable and within certain feasible limits. It cannot become prohibitive, and the worst part of this dimension of cost, if I may kind of put it forth in that manner, is on startups. Right? It's on innovations. It's on new ideas getting identified and commercialized. So I think somewhere we need to view data protection in the larger context of emerging digital innovative economy, without which we would not be able to appreciate this particular issue with the right kind of impact that it is bound to have. And I would like to believe that data protection is very, very quickly emerging as an important critical aspect of doing business in India. And to that extent, the whole world of economy, investments, ideas, and venture funding are looking forward to how do we define policy, law, and economics. Economics, of course, would be a follow-up factor when it comes to if policy and law make it very restrictive, then economics will have its own reaction, as opposed to if policy and law are able to facilitate, will be able to encourage and make it more feasible, then economics would also make it more efficient. Economics would also make it more possible for businesses to uh, venture into this segment and thrive on it. At the outset, I must tell you, I'm not going to be talking about any particular sector. We could always pick on particular sectors and look at it in terms of a segmented way, right? In terms of, for example, fintech, right? I don't think any of us will disagree that in today's world, banks are the biggest entities subjected to this entire possibility of incurring cost of compliance, right? But even assuming we will let it be that, well, banks usually are big enough, resourceful enough to kind of maintain that possibility. But then the issue is banks, if you notice, banks are tying up with many, many startups, right? Instead of duplicating the work done by startups, innovative startups, banks are actually collaborating or even sometimes acquiring startups which are in a position to give them better data protection and analytics. More importantly, data security, like what Professor Kim was mentioning in the previous session, while of course he was looking at it from the model of what would be feasible as in terms of incurring of cost. But a bank is today willing to, instead of maintaining a very huge set of IT professionals within the bank, well, why not we just enter into a contract of service with a startup which is far more innovative, dynamic, and product and service oriented. And to that extent, I think this is an issue across sectors. I'm not looking at only telecom or technology dependent sectors. Those are, of course, extremely, using technology on a day-to-day basis, or for that matter, e-commerce, which is again the spearheading the platform business model in India. But I'm also referring to the traditional sectors of commerce, banking, insurance, manufacturing, right? So these are traditional sectors, or even service, for that matter, education, right? Education has seen a revolution. And if there is one positive impact of the pandemic, if I may put it in that way, I think digital models of education and course material and course lectures online is a very, very big leap forward. And it's an leap that we will surely take even further in the days to come. So therefore, I think data and data protection pretty much give us the universe of issues and questions that we would like to ask of policy, law, and economics. And if I may kindly again clarify, this is purely in the Indian context, though whatever I'm going to be talking about is very much relevant and resonates with different parts of the world. And to be very fair and frank, I think no part of the world has been able to answer these questions in a very absolute or a firm manner. Of course, I would like to again reiterate, please feel free to stop me at any time. I will, of course, give at least 15, if not 20 minutes for discussion at the end of the towards the after 3:30, but even otherwise, feel free to stop me at any time. Let me begin. I don't think I need to tell you, data is all over us, all around us, all within us. In fact, we are the source of data each time we use the mobile phone. And we are talking about, I don't even know how many zeros are there. I don't even want to find out, right? And it is apparently whatever number of bytes. And these bytes are no longer really bytes. They are becoming collectively a huge possibility of decision making, be it in public policy, be it in business, be it firm level, be it sectoral, be it regulatory, right? So I think there is absolutely a lot that is being generated. I don't think there is any two ways of thinking on that line. By the way, this report, I think I've forgotten to put the year. It's 2020 report last year. This report by a committee of experts on non-personal data governance framework, which was, in fact, headed by one of the founders of Infosys. And this report has further cited, I think, another online report saying that while 90 zettabytes itself is pretty daunting, it is going to double in the very next 3 to 4 years. So this is something that we need to bear in mind, that data is here to stay. And most importantly, it is going to fuel the digital economy, right? While people say data is the new oil and whatever else, I think it's better looked at as fuel, right? It is going to spur and fuel the economic growth of the future. And to that extent, it is high time that we got our policy, law, and of course, the economic rationality in place. So if I may begin with the very first part of our theme that I was talking about, that when we say data, what does it mean? What does it refer to? I think we are all very familiar with the very first part of it. I don't have to tell you at all. Our own Supreme Court, way back in not too long ago, I think towards the end of 2017, has now declared that right to privacy is part of our fundamental rights. And this is nothing new. Europe has already done that way back even 20 years ago. They have mentioned that right to protection of data, right? I mean, I should clarify, right to protection of personal data was made a fundamental right in UK as well as in Europe way back in the 80s itself. And in fact, it was part of the Charter of Fundamental Rights of European Union. And as you are aware, at that point of time, United Kingdom was part of European Union, which of course now they have exited. But nevertheless, there was a common framework that took place at that time, and it was for the last 3 to 4 decades, it has been very clearly upheld as an essential part of individual rights, fundamental rights. And we now have a clear articulation of it by the Supreme Court. In fact, Supreme Court has now put in what we refer to as a four-fold test, right, of privacy, that unless you have a particular law, legislation, right, legislation, unless you have a legislation, we are not talking about regulation. We are not talking about just some official memorandum or a notification. But unless you have a legislation, you cannot even access or in any manner invade into the personal sensitive privacy of a person in India, because that is the fundamental right. So unless you have a law, you cannot do it. And then the second aspect of that test is there must be a legitimate purpose, right? You cannot access private information until and unless there is some form of legitimate purpose. Third test is there must be proportional intrusion. You see the careful choice of words made by the Supreme Court of India in saying that, one is purpose, but at the same time, you cannot, using that purpose, invade it 90% or 100%. It is a matter of calibration. It is a matter of proportion. It is a matter of only what is required. Right? And the last test out of this fourfold test is you bear, you meaning be it the state, be it the big technology companies, or be it the what do you call it, the firms, the customer oriented, consumer oriented commercial firms, right? Whoever you may be, the fact still remains that you got to bear the burden of safeguarding the privacy. Right? This fourfold test makes it very clear that we are required to revisit a lot of aspects of our existing policy, our existing laws, and they will have an implication on the kind of economy and economics that we are talking about. Right? So I mean, just to kind of make that clear, that it is personal sensitive part of data is what is well understood, but that also has so many of these complexities. But I would also like to contend that equally important, which is something that we have not paid enough interest, especially in the Indian context, is the corporate commercial part of confidentiality, trade sensitive information, trade secret information, right? In fact, I can even go to the extent of saying, though it's not the right usage, I may want to say it is the privacy of companies, privacy of firms, privacy of startups, privacy of sole proprietors, privacy of retail, right? Privacy of bookkeeping, privacy of accounting, privacy of cost optimization. Right? I could very well give the buzzword of privacy and look at it, but what I mean by confidential over there is exactly that. How do I protect value, trade, business, commercial value? Right? And in the same manner as how Supreme Court says we need to be very sensitive about personal information, well, we also need to be very sensitive about commercial information. Right? That is the new stage of innovation in the world, and so it is even in India. If we don't protect trade sensitive information, we will not have an economy based on bona fides. We will not have an economy based on genuine innovative efforts. It will all be about how do I catch hold of your value and information, which is not the good, or which is not the ideal way for any market to grow. Right? So in many ways, I think corporate commercial information needs a far, or deserves a far greater attention. Unfortunately, in India, we haven't been able to give that much of attention. Perhaps this is the right time. The time is ripe for the government as well as the parliament to think about it as a matter of priority. If I may go ahead and also identify that we also have as a community, as citizens, as collective part of citizen activity, involvement, participation, public, the presentation, public sharing of perceptions or opinions, right? Or even practices, right, at the public level. So we are generating a good amount of data which is collective. I don't mind calling it even open, if I may say, right? Data which is open only because it's there, out there, but not in an organized, not in an accessible, not in a replicable format. But nevertheless, I think we need to have a framework to be able to identify and organize, if I may use the term, organize this data. It helps a lot. For example, urban city planning, mobility planning, right? We have every metropolitan city as a comprehensive mobility plan. But how do we derive that? Unless we are able to look at patterns of urban mobility, the ticketing, um, tariff and fixation of tariffs of urban mobility related, planning and fare fixation is dependent upon what is it that the people are doing, right? What segment of people are moving from which part of the city to which part of the localities, right? What is the connectivity ratio? What is the last mile, first mile connectivity concerns? Right? Now, all these require a good amount of open access to collective data, right? In fact, I would like to use the word crowd sourcing of data, right? In fact, you can actually have a great deal of positive policy and economic externalities based on crowd-sourced, collective, and open data. Right? So I would like to present that we have to think about these three in no particular order of priority, but I think all of these are excellent sources of data, which are extremely important to be dealt and addressed by in terms of policy, law, and of course, economics. By the way, in each of these kinds of sources of data, we have different stages, right? While the top three may be sources, what about stages? And what I have put up here, please note, is just the tip of the iceberg. In fact, I would request you to go and take a look at GDPR, the General Data Protection Regulation of the European Union. As I'm sure all of you are aware, it deals with personal data of any person within European Union. And to that extent, even if you happen to be handling that data in India, you've got to respect GDPR and follow it, failing which there can be legal consequences. For example, as an educational institution, we may be handling data of an exchange student from Europe, in which case we get, uh, uh, within the purview of regulation of GDPR as well. But just to let you know, if you look at GDPR, definitely, I mean, the stages, they have about, I think, 22 stages laid down. What I'm telling you, showing you here is merely just 3 or 4 of them. But there are a variety of different bits and stages of data that will pass through, right? Data passes through a variety of these stages, and we need to have clarity and unambiguous understanding of who is responsible at what stage, right? And to that extent, it has a direct impact on business, investment, protection, and all other issues that we are looking at. And I think this is a point I've already made earlier, and I don't have to emphasize it any further. Right to protection of data is emerging as not only fundamental, but universally across borders, across continents. We are now going to see protection of data as an universal obligation, especially for businesses. So we need to be prepared. And as Indian economy is growing, and we would like Indian economy players to also be, Indian players to be playing a role globally, I think it's high time we are in a position to put in a framework which will enable us to understand the complexities of data and its varied dimensions. Let me move to the second part that I had mentioned, we will take a look at, and under which I think I would like to, more than answering, I would like to raise some questions. Consent, and I'm sure all of you are aware, consent is, in fact, even to log into this meeting virtually, I'm sure you would have had to say, I agree somewhere, right? And obviously, none of us have the time or the wherewithal to sit down and read the terms and conditions of such an agreement. And even if you want to, it's not as if it'll be easy, or it'll be given to you in a manner or in any form which is easily understandable. So how are we to understand that what I have said as I agree actually amounts to consent? Right? In fact, in the world of medicine and surgeries and hospital care, I'm sure many of you would be aware, we have had signing of informed consent for ages. Even today, I'm sure all of us would agree that when we say we are signing that document, well, we are signing that document of informed consent, but it's not necessary that we are completely informed. So I think today it is time that we ask this question of how qualitative, how meaningful, and how valuable is the consent that we are securing day in and day out. Right? Millions of people are saying, I agree somewhere or the other as we speak, online transactions. And to that extent, I'm very sure that in many ways, you will find that these are not things that are prone to ease of access and ease of consumers. Right. And yes, I completely agree with the comment on the chat. Tripti is talking about they use very tough English language. And in a country like India, at least India has some fair bit of English speaking people. But if you go to other countries, especially countries where the social deprivation is very high, education is very low, people would not be in any position to kind of understand the ramifications of such policies, which we are accepting on our mobile every day, right? As you know, more than half the population in the world has mobile phones. Perhaps another 50% of that half may even be using smartphones. And to that extent, I think it is only likely that they are agreeing to various kinds of giving consent to various kinds of policies and business contracts day in and day out without realizing the true meaning or the implication of these kinds of instruments. So let me assure you, there is a word, there is a phrase used in the GDPR, and mind you, we have a personal data protection bill pending before the parliament. I think it has been referred to a parliamentary committee. And that bill is largely, inspired with a reference to the GDPR, because the coming into effect of GDPR and the making of the bill kind of coincided. And I must tell you, the very concept of withdrawal of consent makes it even more complex. So what you are saying is, even if I've given consent, the law may tomorrow allow me to withdraw the consent. What does that mean? What are the implications? Right? That means whatever I've given you consent can be withdrawn. That means whatever you have done in the meanwhile, will it remain valid? What if in the meantime you have already, given it away to somebody else based on my consent? Can I take back the chain of all the following circumstances? I cannot even fathom the kind of legal enforcement issues that will be raised if we bring in phrases like withdrawal of consent, or even simple things like right to be forgotten, right to erasure of information, right? And I can assure you, we are only picking at the top. I'm sure with further experience, we are bound to see many more layers of complexities. Right? Let me also bring in, I think I thank Professor Kim for pointing out some part of what I've mentioned over here as well. Right? We are not talking about only requirements of law or regulator. We are talking about requirements of industry. Tomorrow, industry may move the bar, right? They may move up the bar. Well, if it is a monopoly industry, well, the monopoly sector, then there is an issue, as Professor Kim rightly mentioned, right? They may have different dynamics, but what about industries like even pharma industry? It's very unique. Right, there are a few big players. There are a lot of MNCs, not a lot, but a few MNCs, big, deep pocket MNCs. There are a few big players of India, and there are a host of contract manufacturing, about 300, 350 such entities which are doing very well across the country. Right, different economic capacities. What is their level of data protection? Right, what if industry raises the standard to such a level that tomorrow they cannot exist in the competition? Isn't that a great way of doing away with competition from genuine players? Right. So in fact, compliance can become the differentiator. Compliance can become the competitive factor. And that is something that we need to bear in mind. And of course, added to that is the entire issue of, with greater awareness, with greater education, tomorrow's customer, consumer, citizen will start demanding, will start placing expectations which are much higher than what we are seeing today. So businesses need to be prepared for it. Businesses need to make sure that there is, one is preparation, but the other is costing, right? And which is exactly my next point. Right? What about cost of compliance? I don't want to quote a particular online thing. They have done an estimation. I wasn't sure whether that estimation is entirely reliable, so I didn't want to quote it. But otherwise, they're looking at billions of dollars on just the startup industry. The cost of compliance, and please note, before you arrive at any other conclusion, I'm only talking about cost of compliance of data-related regulations. I'm not talking about cost of compliance of labor laws, cost of compliance of safety laws, health. Those are all in addition to it. Right? So we are talking about tomorrow, if the law comes into place, or even worldwide, we are talking about regulatory filings, audit procedures, public disclosures. Right? I don't know how many of you happen to read in the newspaper just on, I think today is Friday, so I think it was on Monday, if I'm not mistaken. Amazon and Flipkart have said that we don't want to reveal certain things to Competition Commission of India. Why? Because we are not very sure it will remain confidential. Right? We don't want even a regulatory authority to look at some things that are confidential. We want to be able to say we don't want to reveal it because it's very confidential, trade sensitive information, business commercial value of information. But I don't know how far can we provide that, protect that. How far can we really enable that. And before I leave this slide, I would like to kind of mention, what about, in today's world of product and service level innovations, there is absolutely no limitation when we look at technology, when we look at talent, when we look at the kind of investment chasing good ideas. But then, are we in some sense throwing the baby out with the bath water when we say that, but we want to put down a very strict regime of data protection? And in which case, I think at some level, it is bound to dampen innovation. It is bound to dampen the ability of agile startups, people coming together in informal ways, collaborations, joint ventures, open source. I forgot to emphasize on that part as well. What about open source architecture? The entire Android is a great example of open source enabling a wonderful operating system, perhaps by a very conservative estimate, more than 1/3 of the mobile phones in the world run on a system which actually came about thanks to excellent open source collaboration. Right? And to that extent, I think, are we losing out on all those objectives if we are fixated on compliance with regard to data protection? So we need to look at the public cost as well, right? This is a social welfare cost. If we are missing out on better products and better services and innovations, then I think it is a loss which is very notional and cannot really be pinned down to particular values, right? I would like to now come to the concluding part of what I said we will be discussing. I'm going to be just sharing a few questions, after which the floor is open for all of you to interact and discuss. I think data protection, that is policy, law, and economics of data protection, and I'm not talking about any other aspect, I'm talking about only vis-a-vis data protection. I think it requires us to revisit established concepts. It requires us to redesign law, institutions, and regulation when it comes to how are we to put in place this entire mechanism. I think we need to reform, reframe the interpretation and enforcement, and thereby, a direct impact on costs, penalties, impositions, recoveries, compensation. Right? I think the very foundations of civil compensation systems across the world need to be revisited. And I must tell you, starting from aspects of ownership, ownership has been in existence. In fact, people say property and ownership exist even before law was framed, in whatever time of history that we can look back to, right? So, but the fact remains that today, data and data protection is raising fundamental questions of who owns the data that I generate. Right? Do I own it because I happen to be the source, or do you own it because you happen to put in money, effort, time on collecting it, making it meaningful, using it for a larger purpose? Right? You may be, you may be a department of government, you may be a startup, you may be a multinational, you may be a firm, retail firm, you may be an e-commerce provider. Right? Whoever you are as an entity, but you are an intermediary, you are getting some raw data, and you are obviously going to be crystallizing it into some form of meta possibilities, right? And it could help you analyze a lot of things. It's very useful, it's very beneficial. It is beneficial to the whole segment market, in fact, to the whole economy, not just to me as a person. And so there is a lot of value add that takes place. There's a lot of value addition that takes place. But who owns that value added data? That is a question that is still not clear. And I think it is something that we need to look at it. And that goes to the root of ownership, derivative rights, right? So am I giving you a license? Am I giving it to you as a tenant? Am I giving it to you in such a way that improvise it for me? Right? The very issues of tenancy, leasehold, right? Or ownership, or beneficial ownership, or beneficial custody. It raises tremendous number of basic issues of law and economics. Of course, I think I've told you about consent. I don't want to repeat it, but I do want to reiterate and say that the relationship between consent and contracts needs a completely different framework in the context of data. We cannot go on thinking that, well, even if contracts are not negotiated, we should take it as enforceable, is no longer in 2021 a relevant concept to that extent. Well, what about law and regulation? We need to again redesign this entire aspect of what about institutions? Are our courts prepared to look at these issues? Right? Are regulators, SEBI, Competition Commission, Telecom Regulatory, Insurance Regulator, are they prepared to understand nuances and sensitivity of commercial and privacy value of data and speak in cohesion? What if SEBI takes a different stance? What if insurance regulator takes a different stance? Right? Then where do we draw the line? Because banking customer or capital market customers, investors, as opposed to insurance customers, as opposed to RBI taking a particular stance vis-a-vis banking customers, consumers, right? So I think we need to have some kind of uniformity, some kind of minimum standards. I wouldn't use the word uniformity. I would say minimum standards is a better term. And for that, I think we need a comprehensive legislation. In fact, one argument from the industry is let's have a legislation for health differently, health sector. Let's have a definition for financial sector differently. But I think that is not a good, perhaps not a very ambiguous, what do you call it? Not a very right strategy for clarity all across. I think we need to have a minimum standard. And then we can have sector specific, if I may say, growth of regulations as such. And yes, and that brings me to the point that isn't it high time we have some kind of a professional, specialized, more importantly, representative regulator. At the moment, government is doubling up as the regulator when it comes to issues of data protection, and data as a matter of value. At the moment, we only have government, we only have judiciary coming in whenever there are issues. But I think it is high time we had a specialized agency, entity, right? And more importantly, specialized not only in terms of technology and professional expertise, but also in terms of being representative. Please note, this is a topic, this is a theme where business, government, society all need to be effectively represented. And to that extent, I think we need a forum where people are in a position to come and exchange their concerns, ideas, and solutions in order to fire up the digital economy. And I think we need to revisit enforcement, interpretation. If we do have a law and regulation, then we need to adopt a very strong, purposive approach. We need to have a clear, philosophical underpinning that data is actually a public good in many ways, especially the public community oriented data is public good. right? In fact, people are now talking about, government under eminent domain, principle of eminent domain. Government should be construed as the automatic owner of data as a public good, right? Just like how government allocates air spectrum, right? Or government allocates mining rights or land acquisition. And so in the similar way, data is also a matter of public asset held by the government in as a trustee of its citizens. So I think somewhere we need to draw out those lines and make it clear when is data public good, when is data extremely non-negotiably to be left as untouched and personal, and what could be the latitude for businesses to leverage the commercial value of, be it personal data or even commercial value of data itself, trade sensitive business data. And my very last point is, I think we need to have a system of even enforcement whereby we nudge, and I don't have to tell you, nudge is a word that has gained a lot of importance when we talk about behavioral and behavioral based or incentive based kind of policy tools, economic tools that we should be able to incorporate and enforce, especially to regulate the commercial business processors and to empower citizens. We need to have a balance, and that balance is something that cannot be achieved without being able to revisit some of these established traditional concepts, without being able to redesign the law, institutions, and regulations, and as well as the enforcement. All right, I would like to stop here and open up the floor for any questions. I think I took a bit longer than what I said I would, but I'm willing to into discussions. Maybe I should stop share and then help.
Thank you, sir. We do have a question for you that reads whether data protection law would protect privacy and promote growth in India.
Okay. All right. Yeah, I think that's an answer which I would look at it as, which is extremely, if I may say, inevitable, right? So first and foremost, let me kind of address it because both words are used. One is economic growth and privacy. I think the right way to look at it is that we must grow digitally, and I don't have to tell you that growth is now driven by digital models of economic activity as well as platforms, digital platforms, right? So surely I think the future is based on data-driven economic growth. However, I think we should not fall into the trap of looking at privacy as an antithetical to economic growth. No, it is not. I would look at it as, because the future is going to be data-driven economic growth, we need to address issues of privacy, issues of confidentiality, issues of open access, open source, community level databases, database management. These are all perhaps in decreasing order of priority, starting from privacy at the very top. I think these are all aspects of inevitable points of concern that will arise because data is going to drive economic growth. So be it in India or universally, I think going forward, we will have more of data-driven economic growth. Privacy is not a versus, it is not an antithetical notion. It is only part and parcel of how do you make the data-driven digital economic growth
Within the framework of stifling innovation, but Can they protect their systems from non-state actors?
Well, I'm not sure. I don't know, Preeti, if you would like to kind of explain it further. But if I understand your question correctly, I think at some level I will address it at a level of, as I think Professor Kim also mentioned, the traditional logic is, wherever you find competitive forces, leave it unregulated, the market will take care of it. Right. And when you, by your use of the word non-state actors, I would like to believe that it involves broadly two constituents, which is society and industry, business and society. Society means collectively people as well as individually citizens. But I think over here, there is a slight difference when we talk about data protection. It is in the interests of society and business that state should establish an architecture of law and regulation. That is what I meant in my last slide when I said we have to redesign law and regulation in such a way that we don't want to become Inspector Raj, or I mean that's not the purpose, but the purpose is to clarify, set up a, for example, imagine if we have a data protection authority or a data protection regulator. By the way, the bill talks about data protection authority. I would have loved it if the bill said instead of authority, a data protection, officer or data protection regulator, because that's a more amenable word. Authority is almost like a, hierarchical term, right? So that will bring together state and non-state actors, right? That will bring together concerns of innovations, concerns of sandbox innovations. You go to IRDA website, Insurance Regulator and Development, the authority, right? That website, they have a separate division of sandbox, right? That is actually state-enabled innovation, right? So I'm not saying non-state actors alone create competition and innovation. It could even be enabled by the state, but we require to redesign our policies, laws, and regulations to do that. So I'm not sure I understood the point clearly, but I just wanted to use this opportunity to make this point that state and non-state can come together to make it a far more dynamic, innovative way of enabling usage of data while protecting for privacy, confidentiality, and so on.
Sir, Ms. Preeti writes, thank you so much. Yes, it did address my query. Next, we have a question from Radhika. She writes, Sir, what are your views on the new IT rules 2021 with respect to data protection, especially on the identification of first originator of information rule?
Right. I think, Radhika, that's quite a technical question, but you're right. I think at some level, well, see, I'm sure you're well aware that the new rules have kind of run into a lot of compliance issues. More importantly, in fact, that's a good example, right? That's a good example of how complex and how difficult the compliance can become. Even appointment of a grievance redressal officer itself is becoming a contested aspect, and that will add to the complexity as we go along. But let me, Radhika, just to clarify, I think the interpretation of first originator, or I forget the exact term, but essentially those terms, I myself have not really looked at that meaning and interpretation or even possible scope of it. So to that extent, I may not be able to answer you on that. But I must go back and reiterate, these are not issues that can be defined by the parliament as of today. These are aspects that will change depending upon who is your over the top service provider, right? Even Telecom Regulatory Authority of India, which has been in existence since 1999, right? It's more than 2 decades, and yet they are a specialized regulator, and yet they are not able to define so many of these, technology-based, terms or technology-based interpretations. So I think it's a good example of the fact that why we need a separate architecture of law, institutions, and regulator stands, I would say, further reiterated by your question. But as for your actual question of what would it mean, I'm sorry, I haven't myself studied that to be able to share my view freely.
So she further writes, yes, sir, the new IT rules 2021 seem to be inadequate in my opinion and run contrary to the privacy of individuals. Experts need to step in when it comes to this technical field. Indeed,
Absolutely.
ma'am, I agree
Absolutely.
with you.
Yeah.
And so again, there's a question from Ms. Jyoti. She has written, what is your take on right to be forgotten?
Yeah, I mean, good point, Jyoti. I mean, I think right to erasure, right to withdraw the consent, right to objection, right to rectification. Please note, these are all rights under GDPR, right? And right to be forgotten, which I'm told is part of the personal data protection bill of our own country as well. So I think these are all very, very, words which perhaps are powerful, signify a lot, but to be really empowering, to be really meaningful, we have to look at the entire step-by-step process, right? The entire issue, in fact, I forgot to mention that in my talk. There is an entire issue of privacy by design. So how do you design architecture of privacy itself is a very important thing to find out what to go back and reverse, right to erasure, right to be forgotten. All of these are basically where you have to undo a lot of things, and digitally it may not be very easy because one aspect of digital, it's very viral, right? The moment there is one web page created or a web video or a photograph put online, it could have gone to millions of millions of people, and as well as it could have been shared on various peer-to-peer networks. So to what extent can a particular firm or commercial entity ensure right to be forgotten? I think that's a big, if I may say, millions of dollars question. Not just $1 million, it's millions of dollars. And tomorrow, if I don't do it, who will go to court and enforce it against me? So that's a further sword hanging over the head of every business entity. So right to be forgotten is bound to see many lawyers make more money in terms of legal fees. I don't have any doubt about that.
Thank you so much, sir. I don't see any more questions. However, if anyone else has any questions, they may come up. Yes, Jyoti General writes, thank you, sir. It makes me feel good about my future.
Yeah, I think future is certainly bright, Jyoti. Yeah.
And thank you, sir. We have reached, it's 4
Yes.
p.m. now, and we are also joined by Param, sir.
Thank you, and all the very best
you,
to all
sir.
of you. Thank you. Thank you.
Thank you, sir.
Hi, good evening from Singapore. I think it's a bit afternoon there. So Shubhi, do I start or there is some break for participants, or how does it work?
So we don't have a break. Let me check if Ranita ma'am has joined. Yes, yes, sir, Ranita ma'am is here. Okay, so we can commence with our session. Khushi, can you please introduce her and then we can begin.
For our third session today, I would like to welcome, or rather welcome back, Mr. Param Pandya to GNLU. He is a doctoral candidate at the National University of Singapore, pursued a master's in law and finance at the University of Oxford. He's a J.N. Tata Scholar as well as a recipient of the President's Graduate Fellowship since 2020. With immense experience in policy research in areas such as corporate governance, comparative corporate law, business and human rights, and securities law, Mr. Pandya will take up today's session on the topic of directors' duties and stakeholders' interests, a law and economic analysis. We welcome you, sir.
Thanks a lot, Kushi, for a more than modest introduction of mine. So I think from a time perspective, it will be great. I'm looking to wound up most of my slides around 30 to 35 minutes so that I have a case study where I can discuss with participants, and so that it's not more of me lecturing away, but we discussing, so that I also benefit from the discussion that we have. So let's just an overview. I will first discuss governance and enforcement of directors' duties to consider stakeholder interest. Uh, More importantly, I think just briefly speaking, stakeholders, for those who know from a company law perspective, would ask me that there are many. So how do you define stakeholders? They basically are non-shareholder constituencies such as suppliers, consumers, creditors, uh, the society at large, employees, etc. And so if you think data and technology is the current buzzword, sustainability in corporate law, corporate governance is also the another buzzword. The two of the most important trends that we see in current day and era. And of course, this is also going to be bringing you good money. So yeah, one. And then I move on to the need for an enforcement mechanism. And in that itself, I provide four justifications as to why we need an enforcement mechanism, and then proceed to highlight some of the law and economic aspects. I would have already dealt on with it before, and then we discuss the case study. So yeah. So I explain you the what constitutes stakeholders. Traditionally speaking, corporate law has always been a shareholder focused or a shareholder driven uh, legal framework. But with the advent of stakeholder theory, which says that directors should not just be considering shareholder interest, but must consider stakeholders' interest as the end goal of corporate decision making. That is, a company is not just for the shareholders, but also for the stakeholders, and they need to be taken into consideration. So, what is this director's duties? So, if you very well, for those who study corporate law and Indian corporate law in particular, are aware of Section 166 in the Companies Act, which says that the directors have to take care or account for the interest of creditors, suppliers, consumers, environment, and the community at large. Uh, so illustration, I think I can borrow the illustration that we're going to discuss in the case study. That is to say that if a mining project is being considered by a board of directors of a mining company, they have to take into account not just the fact that they would make more profit if they explore in another area, but whether there are environmental concerns, whether the local community is getting unsettled because of such a project. What are the implications for the local communities? Uh, how are you borrowing money? How are you funding it, etc., etc. So it has to consider and resort to a balancing act. Now, here what we discuss currently is the pluralist approach to directors' duties to consider stakeholder interest. In this approach, stakeholders' interest is the end goal. So it is only focusing on the interest of stakeholders, and I think the contrast will be much better when we discuss the enlightened shareholder value approach, where the shareholders interest obtain primacy, whereas you have to do that via incorporating stakeholders' interest in mind. So very clearly how the Companies Act of India in under Section 166 adopts this pluralist approach. So it doesn't clarify how to balance interest of shareholders and stakeholders, and also importantly, stakeholders intersay. For example, employees would be keen if the company continues, but creditors would be looking at it from a different angle because the company is loss making, so they are losing out on every time. So they may want to wound up. So they also different points in time they may also have different interests. This is just a example. So the Indian company law doesn't provide any such guidance in this regard, and indirectly it adopts an approach where the duties are owed to the company, and basically it's a disguised enlightened shareholder value approach. So let's go to what is an enlightened shareholder value approach. The ESV approach sees stakeholder interest as means to enhance shareholder value or the value of the company in the long term. That is to say, if eco-friendly products are going to get more profit for shareholders, it should be resorted to. But if the costs outweigh its benefits from a shareholder perspective, the ESV model doesn't mandate such a adoption. So in case of conflicts, direct conflicts, shareholders' interest will prevail. And the UK's Section 172 of the Companies Act adopts this approach. So directors must promote the success of the company for the benefit of its members as a whole, but in doing so, have regard to the interest of other stakeholders. Just have regard. So this is contrasting. In a contrast to this, we see the pluralist approach, the language which says that they shall consider the interest of ABCD stakeholders, right? So this is the governance approach. The the governance approach or in Australia and Singapore. So I have taken 4 jurisdictions: India, United Kingdom, Australia, and Singapore. And in Australia and Singapore follow a similar pattern. That is, their company law doesn't say whom to prioritize, but judicial decisions and executive committee deliberations have somehow arrived at a conclusion that stakeholders' interests must be considered. And however, in Australia, the priority is more clear. That is to say that the shareholder interests are prioritized over stakeholders' interests. So both of them follow the enlightened shareholder value model. Uh, then the logical question is, okay, fine, they should consider, but if they don't consider, what happens? So what is the enforcement of directors' duties to consider stakeholder interest? In India, where we talk about stakeholder power to be rising and the Companies Act being a promising legislation in that sense, is just textually pluralistic because there's no enforcement mechanism. There is no case law that explains the contours of Section 166(2). How there is no guidance from the government which says that okay, you should interpret the provision like this and prioritize this over that. Probably that might be too prescriptive, but how to do the balancing act is also not available. So also, what are the ways in which an enforcement can be run? That's private enforcement and public enforcement. Largely the private enforcement is direct action, that is an action for operation and mismanagement, or a derivative action, say under 245 class action suits or under the common law, which has been carefully not put in Section 245. But they are woefully inadequate. Also, they are rare. You have seen handful of derivative actions, only 3 to be precise, successful ones prior to introduction of 2013 Act. And post that also, we have seen many procedural barriers that don't lead to a favorable outcome. There is Section 241 in the Companies Act which can allow government to bring an action in public interest, but that too has been very rarely resorted. There are 1 or 2 instances which were done prior only to actually take control of the company rather than actually benefiting shareholders. So the remedies under 241, though there is a general clause, we have not seen yet action in this front. The securities market regulator is wide paths in terms of doing bringing an action in the interest of securities market is a possible contender, but again, so we've not seen action to enforce 166 particularly. Also, there might be certain gray areas as to where and how it can exercise such power. So, as I said, the stakeholder power in India is not as it is made out to be, and there's no enforcement option that we have. The ESV approach in the UK also when they brought in 172, they realized that okay, without an enforcement it won't work. So in 2017 they launched a consultation where they discussed a lot of other options, but ended up on more soft disclosure based enforcement. That is to say that under the provisions of the corporate governance code, which is voluntary, uh, uh, in the sense that it's a comply or explain model, and the section of the Companies Act 2006 requires companies to explain how did they consider interest of stakeholders in key corporate decisions that they had taken in the financial year. This is a bit promising, but it's a very recent introduction, so effectiveness is being questioned. Even in the UK, in terms of private enforcement, that when shareholders want to bring or assuage concerns of stakeholders, it is marred with many substantive and procedural barriers. For example, lack of contingency fees. Now, contingency fees, to those who know, great, is a very important component of successful class actions. That is to say, lawyers get fees or a cut of the compensation if they are able to argue a successful class action in in US courts. Now, this also should not be seen as more business enhancing for lawyers, but if you see in US, the US law firms are more active in bringing a class action suit. So what US law firms do is basically they catch hold of an issue such as these. They reach out to the shareholders who are aggrieved. If not, they might just require or request people to buy one share each, and then they gather the minimum minority required for launching a class action. They file for one and they put this notice up on their website. Anyone who's a shareholder can partake into this proceeding, can get a name joined, and that's how they launch a class action. So this incentivizes law firms and lawyers to take such a initiative, which of course is absent in common law, largely common law jurisdictions. Um, uh, and then in Australia, we see a completely different approach. Australia uses hard enforcement. The Securities Exchange Regulator could basically initiate an action for breach of directors' duties if it is in public interest to do so. While it's hailed for its effective enforcement, there are certain other issues as lower penalties being imposed. The regulator basically adopts a why not litigate approach. That is to say, can this be sorted out without a full-fledged litigation or a regulatory action? In some cases, it's good, but it might also be leading to certain political economy issues. And uh, these are the broad issues that surround enforcement in Australia, but it's still a better model compared to other countries. Singapore also has no enforcement model. Singapore suffers from uh, the same sort of problems. In fact, the practice guidance to corporate governance code in Singapore, which provides generally for stakeholder engagement, has been reduced to a public investor relationship angle. So the requirements are far less demanding than in Australia and UK. So with a broad roundup of how the director's duties to consider its stakeholder interest are governed in terms of the approaches, and how their enforcement is missing despite adopting different approaches. I think now it will be a good idea to move to the next part where I argue that there are four justifications why an enforcement mechanism is required. Now, just as a disclaimer, what is this enforcement mechanism is a matter of further discussion and deliberation, also part of my doctoral thesis. So this is just one more normative part of it. And the details of the enforcement bit, probably I think I can share with you in the next workshop in 2022. The need for enforcement mechanism, I argue there are four clear justifications: the justice justification, synergy justification, stakeholder salience justification, and accountability justification. I'll go to each of them one by one. So it's apparently clear, and I think I don't need to argue more on the first point in with when we talk about lawyers, that a right without a remedy is useless. Well, the definition of right may be tricky, but OECD says that legal requirements that enforce corporate governance, or that basically the corporate governance legal requirements must be enforceable. So and the director's duty suffers from the fact that it is not enforceable. We also have to understand the situation of stakeholders in a corporate setup. Most stakeholders do not have a bargaining power, even with unions, even with or without them, or for example, consumers who have no bargaining power at the time of negotiation, and thus most of them end up into into contracting which is incomplete. Now, incomplete contract again in an economic sense means that you cannot envisage all possible permutations and combinations of events where one party will fail or the other party will fail or both parties will fail uh, in while deciding in the ex ante sense. So this means that there is not enough contractual protections imbibed into this contract for stakeholders. Also, stakeholders are required to make firm specific investments. For example, someone who is making a part of a car in an automotive company specializes in making that specific part of a car. For example, you cannot take him and put him in a power generation company because he is specialized in making that part of a car. Also, even in an automobile company, probably the part of Rolls Royce will definitely not be similar to that of Mercedes. So you know you cannot be even placed in a similar situation. This phenomena of investing in a firm uh, and you revolving around that role is called making a firm specific investment. And in such case, high likelihood of that company exploiting that person because it knows that the person is not cannot be uprooted and cannot shift quickly to another firm. So these are very important considerations from a stakeholder protection perspective. Also, there is no corporate law remedy for stakeholders. Shareholders can bring a lot of actions and can assuage their concerns in court, but stakeholders don't have a corporate law remedy. By corporate law remedy is basically disqualification of directors or company paying compensation. You need a broader set of remedies in the corporate law realm. This would also mean that there are effective linkages or liability mechanisms for human rights due diligence, sustainability reporting, and sustainable finance. So all of these, for those who don't know, briefly, human rights due diligence refers to a concept of uh, a due diligence which is exercised, which is to say that the company, in case of say a third party supplier, is able to vet whether the third party supplier pays its employees well or not, whether there are habitable conditions that are fine, or does not employ children, or does not engage in modern slavery. So these are exercises that sometimes can be also used to limit liabilities, but they lack effective liability mechanism. That is to say, if they don't comply, how does it work? Who should be held responsible? So if you ensure that there is an enforcement mechanism for stakeholders where they indirectly, directly can voice their concerns, they get this right or an ability to say that, you know, there was a failure there. The due diligence was not conducted properly. The employer failed to do that, the principal employer failed to do that, and hence the directors of the principal employer must be liable. In the same way, you just get away with reporting sustainability issues of how this green and that green the company tried to do, but it can be greenwashing, and there's no serious repercussions to that. Companies, even based on these bases that they will engage into greener practices, borrow money from lenders, while lenders still have greater means to enforce contractual protection. But if you want to have a corporate law remedy, they do not. So sustainable finance also could be benefited. So in this justification, I argue that stakeholders will get justice if there's an enforcement mechanism. The synergy justification is a bit complex in the sense that uh, traditionally corporate lawyers, particularly law and economics scholars, think that uh, the theory based on the theory of the firm, the corporate law provides default rules for parties to engage and create a corporation. Corporate law is not prescriptive, though that is changing since long, and we have seen certain mandatory rules like say CSR or directors' duties placed in which are quite a lot above the default rules which parties would want to adopt when they engage into a business in the form of a company. So the traditional conception is that there is external regulation, which is financial regulation, environmental law, labor law, among others, that should do their role of protecting stakeholders. Internal regulation or corporate law only should consider shareholders who are residual claimants and thus care for them. Well, what has happened is that this has led to making corporate law an island. You know, it's a law that only is presumed to only care about the rich, the shareholders, and the capitalists. But that's not true, and that shouldn't be true. So what I argue is that over a period of time, effectiveness of external regulation has been reducing because of corporate power and political power nexus. Corporate lobbying has made external regulations ineffective. And it's just reduced to a tick in the box approach. Like penalties are a cost of business. People can calculate that well in advance and then say, okay, this is the cost, this is the benefit. The benefits are more than the cost. Let's break the law. And I think the Volkswagen emission scandal is a clear example of such a permutation combination. So I suggest that an enforcement mechanism to enforce directors' duties to consider stakeholder interest would complement external regulation. Let's understand this in a brief example. If there is a higher standard for breach of external regulation, the breach of corporate law or the breach of director duties will be even higher because it includes even an anticipatory breach of, say, environmental law or labor law or financial regulation. So what will happen is that if at the board level there is failure to consider interest of say the local community, and the board sanctions a project or goes ahead with the project leading to damages, and then the community goes up, or even at the level of understanding the fact that the board of directors have issued or allowed the company to undergo a project, they can file for an anticipatory breach saying that this will harm either their heritage or this will either harm their surroundings from an environmental perspective. So you see what happens is that the breach of corporate law is a higher threshold for corporate directors to meet, which means the company would want to avoid this liability first before getting into the external regulation liability. So this would mean that they would adopt more stringent compliance program where they want to avoid the liability of directors being sued in the first place, which means they will also avoid a explicit breach of external regulation. So I then suggest that this would mean that there will be synergy between both external and internal regulation, that is non-corporate law statutes and corporate law statutes, to protect stakeholder interest. Stakeholder salience justifications, though, is a more theoretical construct, but generally speaking, it makes clear sense that managers would consider stakeholder interest more salient, that is more important in general sense. So it's a theoretical framework which suggests that if stakeholders possess power, urgency, and legitimacy, their interests would be more salient for managers. Now, power, of course, an enforcement mechanism would give that stakeholders the power to express their concerns and assuage their concerns. It A formal or an informal enforcement action, and I'll go on to the details of what a formal or an informal enforcement action could possibly mean, would mean that the managers would have to deal with that with greater urgency because that's a sword hanging on the head. And the necessary safeguards, that is to say, if an enforcement mechanism is put in, it cannot be free. It cannot mean that any person can come up and then affect the business of the corporation. So there will be certain procedural safeguards that are put in so that the frivolous complaints are weeded out, which means that only those complaints which make sense from a judicial angle or from a private enforcement angle would reach the managers. That gives legitimacy to those concerns, and thus I argue that this as a factor would increase the salience to stakeholder interest for managers. And the last is an accountability justification. I think very clearly anyone who basically understands that, if I say directors are accountable to share body of shareholders, it seems that they only have to keep single focus. But if I say they are also accountable to creditors, consumers, employees, society, and the environment at large, there are many masters for them to serve, and which means they will be answerable to none. And this phenomena has been quite succinctly captured by Easterbrook, and Bepchuk, a Harvard law prof, kind of calls it the perils of stakeholderism. That is to say, directors will lack accountability and they will have an increased insulation from shareholders. So basically, they can say that, okay, you were supposed to make 100 rupees profit for this quarter, but you say you made 90. How? Explain. So the directors will say we paid 10 rupees to the employees, and hence you have seen less profit. But basically they were unable to bring in more lucrative projects, and that could have been the real reason why they wanted to just escape by putting it on stakeholders. So there have to be legal reforms that make directors more accountable, and directors work should be monitored and should have reputational consequences. Also because directors are repeat players in the market, and their reputation is what makes them along with the skills and qualification to be able to be sitting on multiple boards. But given all of this, given all the bad things about companies, let's not ignore the fact that stakeholders could also be opportunistic, and they can have or they can be used in a way to take political vendetta or extraneous interest than the business interest. And thus we need to build the safeguards. If you see stakeholderism or stakeholder theory or stakeholders to be an essential part of corporate decision making. So that's why I argue that if you have an enforcement mechanism, you can make both of them accountable in some form or the other. And while discussing, I've already emphasized on certain law and economic concepts. This might just be a quick highlight in terms of the law and economics analysis. So who are the stakeholders? The definition is also not exhaustive. No statute provides such a definition. How to balance the interest between shareholders and stakeholders? What will be the trade-off? There is no guidance. Is there a possibility of making one stakeholder or a shareholder better off without making the other worse off? Or it's just that if you take care of stakeholder interest, as argued by Alex Edman, a prof from the London Business School, that you grow the pie and then you go on to the division question. Also, very easily we consider shareholders to be a homogeneous class, but we have to understand that they have different interests too. There can be a government who is a stakeholder who doesn't at times care about profit but is more concerned with societal welfare. There can be institutional shareholders who are pro-social, as Hart and Zingales that is Oliver Hart and Luis Ingales call in their recent paper. And they can be motivated towards more social causes, towards highlighting stakeholders' concern in the boardroom. Also, each stakeholder is different and each stakeholder class may vary. For example, the best case is creditors, secured creditors, unsecured creditors. Both of them have varying interests. The secured creditor, so long as he knows or she knows that the property is well more than the value, uh, he or she would want to appropriate the property when the company goes down or goes to the bankruptcy route. So each of these interests are complex, and to understand and to arrive at a balancing act is itself a big trading off that needs to be done. And as I discussed, the fact that there is an accountability issue also complex makes the principal agent relationship concept. Who should the directors be loyal towards? Shareholders, stakeholders, or the company? And the company is an artificial entity. So also they continue to be appointed by shareholders. So they may have a quid pro quo there. Also, when we discuss the type of shareholders, we can't forget family-owned companies in India and particularly in many other jurisdictions, where the brother, the sister, the father, the mother, all of them sit on the boards of directors and they constitute the board. So, do you see then in that case divergence of interest between, you see a conflict of shareholders versus minority shareholders, you see shareholders versus stakeholders, all of these concepts get more complicated. So in terms of the governance approach, yes, that those are the key points that we see from uh, a tangent of law and economics. From the enforcement approach also there are a lot of issues. uh, for example, stakeholders cannot initiate direct action. If allowed, how would it work? For example, in the insolvency, we've seen how home buyers were given the right to launch bankruptcy proceedings, and we've seen the collective action problems that stem from that. Also, stakeholders generally lack resources. They do not have the information, and that's why information asymmetry might come. What were the board's processes that were done? How were they done? Whether they were done or not, stakeholders don't have that information for them to say that our interests were not considered. You will have to wait till the heritage site is blasted off to show that yes, you definitely didn't consider our interest. So that's one of the key issues there. From a derivative action where you assume that shareholders will reach out to the company and say file an action against the company for stakeholder interest, that seems to be quite a bit of a free rider business, because the shareholders will have to, in most cases, only lose out. That is to say, when they sue the company will have to pay damages, which basically means a reduction in the part of the profits. And again, whether the stakeholders would get it or how they will be identified, those remain a lot of questions, apart from other procedural barriers that we have discussed. The informal private enforcement, where the institutional investors, we've seen a great rise in them. Most of them, BlackRock and Vanguard and all, are now trying to be pro-social and pro-environment and pro-sustainability. Would it be would that informal engagement, that is to say, meet the board of directors, convince them that things are going wrong, and remedy them? Would that be more cost effective, more incentive driven? Because these institutional investors are keen to take their portfolio companies to a be governed in a more sustainable manner, or as many have critiqued, is a PR exercise. So these are some issues on the private enforcement front. The public enforcement, where the government or the regulator steps in, is often seen by economists in the sense of theory of unintended consequences. That is to say, regulation can do no good to business. Well, but those belief systems have also been challenged. But still, that still doesn't mean that we do away with economic conceptions of, say, a cost benefit analysis. And what is the regulatory judicial capacity also you put in a place an enforcement mechanism, but if the enforcement mechanism is corrupt and is still seen as an arm of the corporate lobbyists, which is the political economic consideration, it still makes no sense. The increased liability on directors could also stifle directors market. Well, that's an argument someone can make, that if there's so much liability, I don't want to be a director. It can also impair risk taking. That is to say that they won't take up risky projects where there is a conflict or there's a balance, which mean it will overall reduce the economic growth. Uh, these 2 points come from the institutionalist or the conventionalist theory of economics. And that's one. The other aspect is, could public enforcement lead to increased deterrence? As Scooter in a 1990 paper argues that it depends on a lot of factors. It is firstly on the probability of detection. Secondly, if you have detected, how will you enforce, and the probability of enforcement, and the fact that the punishment that has been prescribed is higher or equal to the gain, or else if it's lower, then companies will be encouraged to get that gain because they know that gain minus the penalties is equal to profit. So these are the concerns that stem there. Sorry. The informal enforcement can also be done by regulatory bodies. That is to say, a regulator can just send a warning letter to a company and say, hey, you are not doing good. This is wrong. What you have decided on the board meeting, which we have got the resolution and the copy of, seems to go against security markets, the investors, or seems to go against the stakeholders, the local community at large. Again, the regulatory power to do something must be put in place, because otherwise they can't do it. Or they condemned and give an act of a director, because directors are reputational intermediaries, as I explained, and so such a warning letter or such a questioning, such a fact that you question the role of or the working of the directors, can bring in serious reputational consequences. So these broadly are the enforcement approaches. So we see the fact that the governance, what are the models, what is the approach. In both approaches, we see a lack of concrete enforcement mechanism. I argue for justifications for an enforcement mechanism, and then I suggest the issues that come up in envisaging an enforcement mechanism. I think all of these issues, including the 4 justifications, come well within the purview of the today's case study. I am told that that's circulated to all of you. Uh, It'll be great if we could discuss the same, and I can stop a bit of my lecturing. But if not, well, I think I can just go ahead with explaining the case study. So what's the sense? What's the consensus? Do we discuss, or do we go ahead with my lecturing as normal? I think with no questions, no this thing, I think I'll also explain the case study, and I'll then wait for your comments or questions, if any. So the case study today pertains to a company called Rio Tinto, which is one of the major mining companies in the world, not just in Australia, but in the world. Uh, and its handling of a mining project at the Yukon Gorge Caves in Australia. These caves are supposed to be 46,000 years old, and it's a heritage site for the PKKP community in Australia. What happened here? Basically, it was seen as a viable mining project. The board of directors agreed to sanction it. The legal requirements, as alleged by the companies, were met with, surprisingly, and they blasted the sites off. So you basically saw that it threatened the cultural heritage of this community. And on the ex post sense, it was realized that it was a grave error on the part of the board. The board had three options where it could have not led to the blasting of the site, but somehow, and again, the company has been very clear of this, though, that it was their error at the highest level where they just missed this option. So a clear example of how they didn't consider stakeholders' interest. And these stakeholders are a very local community, very close knit to that area. So it's how the processes and how the lapses went on. I think I'll leave it to leave you to read the board's report, where multiple times they have said that it was a grave error, it was an error on their part. But the loss of heritage is true and very effectively cannot be restored, though the company has been ordered to do so. So let's look at then the consequences, what lies ahead. The CEO resigned, of course, took the full responsibility of the issue and resigned. There's a recent dialogue where the Aboriginal community is basically asking shareholding rights of the company. So you have to restore the site. At the same time, what is the surety that they will not do it again? And they're seeking a board representation by virtue of a shareholder's right. So you see that in this explanation itself, we see that a lack of a proper enforcement mechanism. So while there is enforcement mechanism in the sense that directors' duties can be publicly enforced, and the Australian regulator also issued certain warning letters to the company based on which the company actually conducted an internal inquiry. At the same time, a parliamentary inquiry was put in place, which basically also came out with similar findings. And then damages or restoration was made. But you see that there are heritage protection laws also in Australia, but somehow the political lobby is such that if the appeals of companies are generally accepted in 98% cases, if the local or community or the other stakeholders object. So what is this case study for? We see that the board's failure to consider stakeholder interest is a reality. It's also true that it can have serious repercussions which cannot be undone. There are enforcement issues which basically leads to the fact that stakeholders have no remedy. They need voice, and they need that sense of justice to be there, even in case when they're fighting a behemoth like Rio Tinto. The external regulation, the heritage laws which gave permission, which have to protect, seems to be ineffective when it comes to corporate lobbyists and when it comes to huge corporations like this. So we need the company law and the external regulation to talk in sync, which is the synergy justification. These stakeholders need voice. Hello. There's some disturbance. Shubi, could you mute?
Let's be organized. What is this noise? Shubhi?
Thanks, ma'am. I think now it seems so.
Shubhi, please ensure that our participants are muted. Again, there is some noise. Shubhi? Could you please mute yourself? Rajneesh? Rajneesh, could you please mute yourself?
Okay, so yeah, now we can proceed. So we see external regulation also seems to failing. to be failing, and thus the synergy explanation. Of course, the board accountability, despite they accepting it, is still less than destroying the cultural heritage. So you see the whole governance approach, the enforcement approach, the failure of the board, and the justifications that I argue come to light in this one case study. So I think that's it from my end. And you have, if you have questions, comments, we have all the time for that. I think I will stop sharing and we can go ahead with discussion. Yeah, I'm looking at the questions, but there is some. I can't look at the questions properly. Is there any other way that I should be looking at? Or there are no questions? And I was absolutely clear, for which I think I doubt myself.
Param, there's actually, I think it takes time for the questions to come. There's a technical on that.
I'm sorry.
So every presentation, it generally happens, 3 minutes or so, and then we have the question.
That's fine. That's fine. I was not aware of it.
In the meantime, of course, very important questions that you have raised, Param. But an observation that, there is this, when we say that economists are not, don't like regulations, economists say that regulations, erode into business sense. So I'll just make a distinction there. It's only the neoclassical economics, that takes this line of argument. And of course, for the last 200 years, neoclassical economics has been the dominating narrative. But especially when we are doing law and economics discussions, wherein we talk about the importance of regulations, we need to even take from scholarship. For example, I'm sure you must have read Burl and Means 1932 paper, classic paper that actually, roots for regulations given the agency cost problem. And more recently, if we, take from the scholarship of Professor Pistor, Katharina Pistor, who in her Code of Capital, and her work is also on corporates, she takes it even further. She is not talking about the need for regulation. In fact, she takes it further and she says how regulations have also become a manner of, state crony capitalism. So it's gone to that level. So that distinction would be very helpful, for scholars.
Yes, perfect, Pam. I think even I have mentioned, I've cited Pister. I've also cited Boolean means generally. So I agree that the clarification is needed for that. But what the problem is that not just that the fact that neoclassical economist has been a dominant one for quite some time. It's actually the dominant, and it still remains the dominant voice in corporate law and governance. Unfortunately or fortunately, whatever may be the rationale. So I completely take your comment on not generalizing it there. But unfortunately, the dominant view in corporate law and its economic analysis remains that that a regulation is harmful, and when corporate law reforms are brought to assuage stakeholder concerns, it is problematic, or it even it's still like a 2017 edition of a very famous book called The Anatomy of Corporate Law says that it's the corporate reforms aimed at stakeholder protection are not just harmful to corporate law but to stakeholders at large. My intention was to provide a dominant view. I hope that clarification helps.
Yes. Are there any questions?
Hello, ma'am. I have not received any, but I request participants to put forth their questions. And in case if you want to unmute yourself and talk, you may do the same as well.
Param, it seems your session has been crystal clear.
Wow, I think that's quite a compliment. Maybe or maybe not.
All right, Shubhi, then I think we can conclude this session and, wait till the next session to start. Shubhi?
Yes, ma'am, indeed. Thank you so
Please
much
take-
for joining, sir. No, sir, we have a question. I just received one.
Okay.
Okay, so it's from Ms. Jyoti Jinder. It's a rather long question, so I can understand the delay. Okay, so she writes, giving stakeholder protection rights seem to be in the interest of large companies. Do you not think that they will try that such a regulation or amendment is not brought about?
So yeah, and then that's what I refer to as political economy considerations, that they will lobby against such a change. But so these concern always remains the fact that companies would not like a regulation or an amendment to be brought. But again, the larger interest must be seen. So while there are pro shareholder lobby, there is also a pro stakeholder lobby, and mostly regulations lie in between both of these lobbies. So I get that that's a legitimate concern. Also, stakeholder protection, it will not be as direct as what you seem to argue or suggest by the language you've written. I'm not advocating, as currently it stands, that stakeholders should be given the right to file direct action against companies, because then that will also lead to other problems of judicial capacity and how those complaints are handled, whether they are motivated or not. So there are various formal as well as informal means which so I'm not arguing for an overhaul. What I'm arguing is that there can be small tinkering that can be done in terms of the powers to the institutional shareholders, or regulators adopting a more informal approach rather than a formal approach. So there are ways and means which might not be too intrusive to businesses, yet they provide an avenue for stakeholder engagement and protection of their concerns. So as you may note, that part is bit or rather the normative part that I would want to argue as a part of my doctoral thesis, for which I still have some time and I still need that clarity. So exactly what will be the tools, but yeah, so that seems to be a clarification for that.
Can I make one point?
Yes, sir.
I don't know, but like how to trade off between, yeah, how to balance between stakeholder versus the own companies who are working. Yeah, the directors, yeah, CEO. I think it vary from country to country, and we don't know where to get the balance. So this trade-off, you when you complete your PhD, still there will be uh, not settled answer. That's what I that's what was my observation. I don't know what you want to call. What you want
No,
to
sir,
say.
I don't think that needs me to complete my PhD. So I am not arguing here between the shareholder versus the stakeholder debate, because that's a 1930 debate, as ma'am discussed about the Burley Means article. It's a Burley Dodd debate, which is still not settled. So I am not arguing that either of these needs to be given a primacy. But what I'm arguing is, in the recent trend, as you see, stakeholders have been given the right to be considered in corporate decision making. Now, that's a thing that is there, that provision is there, and that interpretation is there in all these four jurisdictions. So, when you have a provision which is just reduced to the law in books, you need to see that in action. And if you need to see that in action, there has to be certain enforcement to make that provision realistic. Or the other one, and the retrograde step, would be to just eliminate out of that of the statute books, which also doesn't seem as likely. So the attempt of my thesis or my proposal is not to dwell into the shareholder versus stakeholder debate, but given the trend, and and there's literature which says that stakeholderism or stakeholders' interest will continue to be important as we move towards in the future. And so, if you consider that corporate purpose and sustainability and stakeholder debate to be important, then might as well make it enforceable. If the whole question is not having that at all, and we resorting to the 1970s Friedman doctrine of saying that it's only the shareholders and nothing else that matters, then that's a different thing altogether.
So we have Jyoti Chandra writing, Sir, if the mechanism provided as an informal tool to settle stakeholder grievances lacks legal accountability or enforcement, do you think the companies at large will follow it?
So I get the sense of jitteriness to see informal regulation as regulation in the first place. But let's understand how it works. For example, there is a company which is not naming, polluting or having a copper plant and polluting the areas nearby. There is merit to say, if the Securities Exchange regulator SEBI writes a letter to that company and says, and of course it's a, of course listed company, that you are polluting and this might create troubles, or we have received complaints that this is happening, and after, of course, recent verification, there is immediate reaction to this in the stock market. The stock of that company will plunge. It did plunge in fact, and I'm giving you a realistic example. So shareholders will see a drop in their wealth directly. Further, if that complaint turns into an action by the external regulator, that is to say the Environmental Protection Authority takes note of cognizance of such an issue and then investigates, again there will be penalties and fines which shareholders are only going to pay. The money at the end goes out from the profit. So while it might seem that this is an informal mechanism of writing letters or regulatory censure or reputational consequences, uh, it still has merit because of the market forces which would determine that this is a good thing or a bad thing. So while we may be very apprehensive of it, for example, even if an institutional investor like BlackRock goes to the board of such a company and says that you're polluting and we've got notice of it, and we invested in you because we knew you are an environmental friendly company, and threatens to pull back the investment, there are serious repercussions to the fact that not just the share price will fall, they will not have money enough to meet their project requirements, and can have serious repercussions. So let's not. I suggest that these informal mechanisms in a given point in time, in a given manner, do play a role which is far better in terms of a formal action which may require the political will and the regulatory capacity, the judicial aptitude to understand and appreciate such issues. Whereas you have a whereas you have market players who are very sensible and can basically try and do something which is far more important or could lead to a positive change. So I'm not dismissing any of these mechanisms. Both formal and informal can complement to achieve the purpose.
Thank you, sir. I have not received any more questions.
That should be then the end of the session.
For this academic program, Param, yes. And we will see you soon in our next schedules.
Sure. Thanks a lot, ma'am. Thanks a lot, Hitesh sir, Ranta ma'am, and Shubhi for inviting me and for moderating taking care of the technical matters. Looking forward to seeing you again, all of you.
Thank you so much, sir.
For the next session today, we have Dr. Regis Lagneau, who is a French academician and the director of undergraduate program in law and economics, as well as the co-director of the master's program in economic regulation at the University Paris West, Nanterre-La Défense. Dr. Regis has been associated with the GNLU Center for Law and Economics for quite a long time and has conducted capacity building workshops, course, certificate, and other conferences with the GNLU Center. We are quite pleased to have you here today, Professor.
Thank you. Can everybody hear me? Yes, no?
Yes, Reggie.
That is fantastic. I will now try to see if it's possible to share my slides.
And
I'm
hello,
assuming-
Reggie.
Sorry?
Hello.
Yeah, hello.
Yeah.
So is it working? Just trying to see if it is working. So are you seeing my slides?
Yes, so we can see your slides.
Okay. So good afternoon, everyone. As Shubhi already told you, I've been associated with the Law and Economics Center for quite a long time. I think that the first time I came here was in 2015, I think, or something like that. And since this is the end of your program, and I know that you had a very productive weeks and you had the possibility to discover a lot of different research regarding law and economics, I wanted in this session to go back to the basics. Of course, but that goes without saying, I'm thanking all the organizing committee for having me here. So as I told you, I want to go back to the basic, and since I'm assuming that most of you are also lawyer or law student or aspiring lawyer, then we need to ask a few questions, because when you are presenting law and economics to a lot of people, and including, by the way, in GNLU, because the Law and Economics Center in GNLU, of course, will consider that law and economics is relevant, but I'm also convinced that that's not the case for everyone in GNLU. Because for a lot of people, when you are looking at law and economics, you are saying, okay, what exactly are we doing? Some people are saying that the first thing that we're doing is just mathematics. You had few presentations that were using mathematics, graph maximization, and at the end, a lawyer could say, okay, so what you are doing is just math using law. How is that relevant for me as a lawyer? How is that relevant for me as an academic? Some other people will say, oh, law and economics actually is quite fun because it offers many counterintuitive and many very offensive results. If you did not read that paper, I'm encouraging you to read that. In 1977, Richard Posner and Elizabeth Landes wrote a paper on the economics of baby shortage. And basically, what they're saying at the end is why not deregulating the market for adoption and introduce a free market approach for allocating babies, which was something that was quite offensive for a lot of people, and you have a lot of literature on that. I also found one law and economic paper which was quite nice because the title of the paper was basically how should you treat your slave if you are aiming at efficiency. And of course, at the end, what they were saying is that you need to treat him as a free man. Some other people might say, okay, law and economics, I'm understanding what we are doing, and I'm understanding this is a new approach to law. But in a way, isn't it some form of a luxury? Because when you are going to look for an internship, when you are going to look for a job, you are going to stress the fact that you know the law. You are not necessarily going to stress the fact that you have been trained in law and economics. Or if you want to stress the fact that you have been trained in law and economics, sometimes it's very difficult to know exactly what to say. Because, yeah, how am I going to sell it, right? Some other people might consider that law and economics, this is neoclassical economics. Neoclassical economics is Chicago. Chicago is Friedman. Friedman is neoliberalism. So it's just ideology. And considering it's just ideology, I don't want to talk about it. So at the end, the question is just that. How could law and economics really contribute to improve your skills as a lawyer? And for a lot of people, these questions remain relatively unclear. And I do not know exactly what to answer to that. Or at least for some of you, this is something that you might say. And the answer, and what I would like to stress during these 50 minutes, is that the reason why you are a better lawyer when you know law and economics, it's because you are going to have a very strategic approach to legal problem. And you are not only going to consider that the problem that you are facing is just a legal problem that should have a legal answer, and for that I need to find a relevant case law and all the things. No. What you have in front of you is just a problem, and you need to find a solution. This solution could be a legal solution, but there are many, many other ways. And this is what I would like to stress. So if you want to participate, do not hesitate to unmute yourself because I will ask you a few questions. And if you do not want to participate, I will answer as my student would answer. So the first thing that I would like to stress is that for law and economics, law is just a means to an end. What does it mean? It means that you, as a lawyer, what is your job? Your job is to find a solution for your client. And the law is just one way to find a solution. And there are many, many other ways. And I will take just the example of a contract. For most of you, I'm assuming that you had a class in contract law at some point. And if I'm asking you what is the purpose of the contract or what will be your function as a lawyer, what would you answer? What is the purpose of a contract? What are you trying to achieve? If nobody is talking, then I will answer. But what are you trying to achieve? Okay. So a lot of you might say that what I'm trying to achieve is that, what I want is I want to protect my client. And for most of you, this is how you are going to consider a contract, right? When I'm going to draft a contract, when I'm going to look at the different clauses of the contract, I will try to say, okay, how will it be possible to protect my client? How will it be possible to have the best contract possible for my client? But at many levels, just considering that the purpose of your contract is to protect your client is quite naive. And why is it naive? Think about it, especially in India. That's the case also in France, but how long will it take for you to obtain a compensation if you decide to sue? 7 years? 10 years? How much will it cost? Because as you know, and that's the reason why for most of you, you are doing the law school, you want to become lawyer because, yeah, as lawyer, we are making money. So how long will it take? How much will it cost? And actually quite a lot, right? And you're going to say also, what are you doing the contract? You're not doing a contract simply because you want to have the possibility to go in front of a judge. You are making a contract because you want something, because you are considering that there is an exchange and this exchange could create value. And what you want is to obtain the value from this exchange. And if you are thinking in terms of law and economics, you're going to consider that, yes, a contract could help you to achieve that, but there are many other ways. And if you are just traveling a bit, you're going to see that, well, what we want is just to facilitate some form of exchange. And exchanging with like a foreigner, exchanging with someone you do not know is in a way something that is risky. And that's the reason why you want to have a contract, okay? But there are many, many other ways to ensure that the exchange could happen. If you're traveling a bit, you are going to see that, okay, what are the other ways than just a contract? If you know a bit of legal history, you know that for the longest time, Japan did not have contract law. For the longest time, Japan were just relying on some other mechanism. And they discovered that a contract law could be relevant when they were dealing with American people. If you are going to China, you are going to discover something that is quite interesting. A Chinese will never sign a contract before a dinner. First, you will need to have a dinner. Why? Because during that dinner, we are going to drink together. If we are drinking together, we are becoming friends. If we are friends, I'm not going to cheat on you. If I'm not going to cheat on you, then we are finding a way to consolidate the exchange, to formalize the exchange. And the contract is just a piece of paper, like, so that, I mean, worst case scenario, I can use it. But what matters for me is something that is very different. Okay? This technique is not a technique that you are finding just in China. If you are going to Mongolia, if you are going to Vietnam, this is something that will happen. Okay? Same thing in India. In India, I would encourage you to ask, I don't know, the owner of any shops and ask him whether or not he's using contract law. And you are going to discover that most of the time he's not using contract law. And why? Either because he's only dealing with people who are belonging from the same caste. And the idea is what? If you are belonging from the same caste, and if you are not behaving as you should behave, then what will be the consequences? The consequences that everybody will know you are going to lose your respectability or part of your respectability, or nobody will want to do business with you. And because of that, I do not need contract law. Like the sanction that will be the social sanction will be way sufficient. Okay? In Gujarat, for example, I learned recently that there is a diamond business that exists in one city and everybody knows each other. Do you really believe that they are using contracts? Absolutely not. Okay? Contract is required precisely because I'm not dealing with people I know and because I'm not dealing with people who could be forced to do what I want them to do because of some form of social sanction. Some people, and for the longest time that was a way, you could marry kids to secure a merger or to some other deal. Like, for example, regarding land, in Europe for the longest time in order to secure a merger of different lands. You are marrying your son with the daughter of, I don't know, the farmer who is living next to you in order for having a bigger land. If you are looking at what is happening in private law, most of the time in private law and in procurement contract, you are using scorecards for your supplier. So what does it mean? It means that you will have like a card that will record your performance over the period of the contract. And at the end, or if you are falling below a certain score, I'm going to sack you and we're not going to do business together anymore. And what is great is that this scorecard could be known by some other people. And because of that, you will not have any incentive to behave badly, right? And actually, these mechanisms could be way more effective than the law. Of course, you have another mechanism that is a classic mechanism, which is violence, okay? You're not doing what I want you to do, then I will send you a big guy, and that big guy will break your leg. That's also a way to secure a contract, right? And as I understood, there are still some countries in which this is something that you are using. And actually, this is something that you are using when the contract is illegal. For example, if you want to sell drug, in general, you are not relying on a legal contract. You are relying on some form of violence in order to ensure that your contract will be respected. Okay? It is thus clear, and that's something that is quite important for me, that things are very different between a one-shot contract, so I will not have any repeated interaction with you, and a procurement contract, like you're my supplier, or you're my supplier, and we are having a 10 years experience together, working together, and all those things. Okay? It's also pretty clear that the legal approach of things is not the only possible approach. And the thing that is quite interesting is that if you are looking at the law as such, you're not going to see any distinction. But maybe if you are having a procurement contract or a one-shot contract, maybe interpretation should be different. Maybe if this is a procurement contract, like I will have to pay attention, for example, when I'm taking into account the trade practices. But if this is a one-shot contract, then yeah, trade practices, maybe I should use that. And I'm pretty sure that in India or in France or in Germany, and actually I never found any country that were making this distinction between a one-shot contract and a procurement contract. So if we're not making that distinction, then we're missing something. Okay? So that's a point that I believe is quite important. The second thing that is extremely, extremely, extremely important is that when you are going to negotiate a contract, if you know a bit of law and economics, you know that what you want is what. You discovered that through the contract, it's possible to increase the welfare of both parties, right? This is one of the big things that you are learning when you are doing economics, okay? It's not a zero-sum game when you are having an exchange. An exchange is a positive sum game. What does it mean? It means that when you are negotiating a contract, or when you are saying that my client would like to have this clause in that contract, what do you need to do? You do not need only to consider what is good for you. You need also to consider how what is good for me is good for you. And that's something that is extremely, extremely important because you are going to go way quicker when you are going to negotiate a contract. I knew someone who told me that whenever he's entering in order to negotiate a contract, he's saying, I do not want to have a junior lawyer. I want to have a senior lawyer. And why did he want it to have a senior lawyer? For one obvious reason. A senior lawyer will not just try to tell you, oh, you know, I want this clause or I want that clause because this is good for my client. A senior lawyer will tell you, I want this clause because, of course, this is good for my client, but this is also good for you and for that reason. And if you are becoming a lawyer, think about that. Like when you are considering one clause, The purpose of that clause is to increase the welfare of both parties. The purpose of that clause is not just to redistribute wealth. And that is extremely, extremely important, especially when you are having a procurement contract. Okay? With one-shot contract, yeah, the purpose is probably to redistribute wealth. No issue with that. But if this is a procurement contract, consider that. Okay? I'm here to increase my welfare, but also to increase your welfare. And if this is clear, and if the parties agree on that, then what will be the result? The result is that we are going to trust each other. We are going to lower the probability that you are going to behave in a very opportunistic way whenever you will have this possibility. Okay? And that's something for me which is extremely, extremely, extremely important. The other thing that you are going to learn when you are going to do law and economics is that when you are negotiating a contract, you could also explain why, of course, this clause is good for you and why this clause is good for me. But sometimes you are going to design the contract in order to force the person in front of you to reveal its type. So that's something that will happen when you will have to select someone. So the typical situation is you want to hire someone who is going to sell something in your shop. And you're offering two types of contract. One type of contract, you have a fixed salary, and this is how much you are going to earn. Second type of contract, fixed plus variable, depending on the number of stuff you are going to sell. And if you are designing the contract properly, it will be relatively easy to identify which applicant really want to work. And the applicant which will really want to work will probably be the one which will prefer to have a variable part in his contract. And as a lawyer, this is also something that could be interesting when you are negotiating something. You could also say to your law firm that, yeah, fix, there is no problem, but actually I prefer to have a lower fix and a higher variable part. Because by doing that, you are just signaling to the firm that actually you are quite a good guy and you are ready to work, which is something I believe is quite important. Okay? The other thing that you are learning when you are doing law and economics is not just that law is just a means to an end. It's not just that, yeah, there are many, many ways to achieve something that you could have achieved through a contract. You're going to learn that it is almost always better to settle out of court. It is not making sense to go in front of a judge. Of course, your client might want to go in front of a judge by saying, yeah, but I need my problem to be recognized as a real problem and I need justice or whatever. But you need to understand that, yeah, if a problem occurs during a contract, suing will never be the best option. And why is that? For many reasons. First, it will take time, it will take money, and up to some point, the result will be uncertain, especially if you are having some form of, I don't know, corruption or whatever, the result will be quite uncertain, right? And once again, I'm not sure that the reason why you are doing a contract is because you want to have the possibility to go in front of a judge. You have many, many costs. You have the stress, you have all the things. And by the way, that's the reason why a lot of companies decide or prefer to use arbitration over the formal legal system that you are having. And that's something that is perfectly normal, okay? And of course, when I'm saying that it's taking time, it's take money and all, it will depend on the institutional structure, okay? How long will it take to obtain a decision? If you are in a legal system that will take something like 3 months, yeah, your incentive to sue will be way higher. But if it's taking 10 years, maybe you should try to find some other way to obtain what you want. Okay? The time to obtain the enforcement of a decision, because as you know, it's not because you are winning a lawsuit that everything will be enforceable right away. Sometime you will need to obtain another document, that's especially the case with arbitration, in order to have the possibility to enforce. Risk of corruption. If you are in a country in which, yeah, you know that judges are corrupted, then maybe trying to go in front of a judge is not necessarily making sense. And all that will take money, all that will take time, all that will take stress and all the things. Not something that you want. And if you are adding on top of that, for example, a level of legal certainty that is not perfect, then what will be the result? You're going to say, no, 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 no. I don't want to go in front of a judge. And actually, this is not what I want. Okay? What I want is what? What I want is to have a solution that will be a quick solution, that will be a clear solution. And for that, I could opt out of the formal legal system. And if you are thinking once again about arbitration, you are going to discover that arbitration was not something that was created by the legal system. It was something that was created by companies, and then the legal system recognized arbitration. Once again, more or less. Okay? But that's something for me that is extremely, extremely important to understand. Okay? What exactly do you want if a problem occurs? If a problem occurs, you do not want to go in front of a judge. Going in front of a judge is the last resort. That's not what you want. Okay? What you want, once again, is to create value for your client, is to create value for the other client. You could discover, for example, that in China, what will happen if you're not paying me? And in China, they are saying that, yeah, that's normal in a way if you are not paying me and if you are like a small firm. Because, I mean, I can understand that you are having problem, but just tell me. Because if you are telling me first, I will understand, or I can understand. And that will not I will not sue you right away. I will give you some time in order for you to pay me. And this approach is so much better. Why? Because once again, you're saying a contract is trying to create a partnership. Okay? Both of us are going to make money out of it. So I'm not going to sue you. There is no point. Okay? What your clients want is the good. What your client wants is the service for which he or she paid. This is what you want. Okay? If I am, I don't know, let's assume that I'm building an airplane and there is some parts that are not going to be delivered. Like suing you, it will take time, it will take money. I will have to find another supplier. How long will it take for them to provide me with that piece? It will take a lot of time. And by the way, that's the reason why if you are going to the aerospace industry or any industry that is extremely, extremely relying on certain pieces, you're not just having one supplier, you're having many suppliers. Because in case one supplier is not doing its job, you will have the possibility to go to another supplier. And by the way, because the suppliers know that, he knows that he's going to lose a lot of business. And because of that, he's going to behave as you want him to behave, which is something that is quite important. Okay? If you want to avoid opportunistic behavior, one of the things that you need to do is to create loyalty. And to create loyalty, you have to show that you're not going to sue, you're not going to be like fully legalist and saying, yeah, what you provided was not exactly what I wanted. Okay? So if you are understanding, and this is like the core idea of law and economics, that if we're exchanging, it's because it's creating value, then you are understanding that the contract is just one way to do it and not the only way. The ability to sue is just a credible threat. Okay? It's just something that will push the other party to change its behavior. But that is all. Most of the time, you do not want to have more than that. Okay? And most of the time, yeah, this is a threat, but this is a threat you do not want to use. You're going to sue if and only if there are no other option. And one of the cases in which you do not have any option is if you are facing a bad face from the other party. And there is one thing that you are going to learn, and which is which might seem quite disturbing if you are a lawyer, is that there is no contractual ways to protect yourself or to protect your client against someone who is going to behave in bad faith, against someone who actually does not want to do his job or who is going to be opportunistic. So what does it mean? It means that before signing a contract, it's always better to learn about the client, okay? To learn about his history, to learn about and the history of the party with which he wants to deal with, okay? And the thing that is quite fascinating is that once again, this thing that seems almost obvious for someone who has been trained in law and economics is absolutely not something that you are learning when you are doing a contract law class, which is in a way quite disturbing, for me at least. The last thing you are going to learn regarding contract law is that you're going to learn that the court decision is not the end. A court decision could just be a beginning. Why? Because you have learned the co-theorem, and the co-theorem is just saying that, yeah, once the entitlement has been allocated, you can reallocate them ex post. And that's something that is extremely, extremely important. But what does it mean also, which is something that is quite important? Sorry, I'm moving. Okay, so it was not here. So what you are going to learn when you are going to look at that is that actually you're going to sue if and only if there is no legal certainty. If there is a sufficient legal certainty, you do not have any incentive to sue. So what does it mean? It means that actually the reason why you are going to sue is because you want the judge to allocate the right because the law is unclear. And once the judge allocated the right, what you can do is try to buy back that right if you are valuing it more than the other party. Or you can try to, and that's one of the way also, you can buy back your client or, buy back the company with which you were having a lawsuit in order to solve the problem. And one of the things that is quite interesting when you're looking at the facts is that it's not something necessarily that we're observing a lot. So there are many, many ways for which we are not observing that. I will not enter into that. But as a lawyer, I think that it's extremely, extremely important to also tell your client that it's not because he obtained the decision he wanted in front of a court that things are over. You still have the possibility to negotiate, as it has been called, in the shadow of law. And that's something that is, once again, extremely, extremely important. And all of these things are not things that are taught in traditional law courses. So the reason why you are doing law and economics in large part is to have this view from the top. You're not just looking at the law, you are saying, what do I want to achieve? Is the law the best way to achieve what I want to achieve? Are there some other way to obtain what I want? Okay, so that's the point on which I wanted to insist a lot. Of course, law and economics is not only relevant because of that. It's also relevant because it's providing you with some new tools, which are extremely, extremely interesting. If you are doing competition law, for example, and more, if you are doing competition law in the US, or if you are doing competition law in Europe, more and more you are going to need to have economics experts who are going to use econometric models in order to have an idea of what will be, for example, the consequences of a merger. You had one case, for example, in the US, I think it was the Home Depot case, and the lawyer fought on which was the most appropriate econometric model to have an idea of what will be the consequences on the prices after the merger. And if you have no idea about what is econometrics, if you have no idea of what are these statistical methods and these statistical tools, you will not be a good lawyer. It's impossible to be a good lawyer. If you're understanding these techniques, if you're understanding the limitation of these techniques, then you can play with it way, way more. Statistical methods are also used for in discrimination cases. How can you prove that were discrimination? Of course, someone could arrive and say, look, the last two person who got hired were, I don't know, male. So there is a discrimination against women. If you are using statistical methods, you can prove that actually, okay, it could be unlikely, but it's not that unlikely because this is happening normally in something, I don't know, 15% of the cases. Okay? The second tool that you are learning is game theory. If you're learning game theory, you are going to discover like new things. First, you are going to find new ways to argue a case. Once again, in competition law, the idea of tacit collusion, for example, was something that was just created by economists because they developed game theory to understand how the different firms could behave. And without talking, it's possible to prove that they are actually colluding to obtain what they want. It's also something that will be relevant if you want to understand international law or if you want to understand just when enforcement is required and when enforcement is not required. Okay, and I really believe, and actually right now I'm working on that in part. How is it possible to use these mechanisms that we are observing at the level of international law at the level of the local law? And if you are looking at all these approach of regulation which are core regulation, in which you are asking for the opinion of the different stakeholder, you are going to discover that actually what is the idea behind that? The idea is to create trust in order to lower the level of enforcement that will be required. Because if everyone is understanding what is the purpose of your law, if everyone is understanding what is the purpose of your regulation, logically, enforcement should occur more naturally. Okay? I could also have mentioned the fact that law and economics help you to think outside of the box. You know that in Europe, for example, a lot of people were considering that Uber was actually the employer of the drivers. Some people are saying, no, 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 no. What is Uber doing? Uber is not doing that. Uber is a trust provider. What exactly does it mean? It means that, as you know, and I'm assuming that this is something that you might have heard, never enter into the car of a stranger, right? But still you're entering in the car of a perfect stranger if he's showing Uber or taxi. Why is that? Because Uber is in a way ensuring through the rating system and all that you are going to be relatively safe. And because of that, actually, I am going to pay Uber in order to have this label of I'm safe, or I'm ready to be graded, or I'm ready to be tailed when I'm providing a ride. And from that point of view, a driver is actually buying a service provided by Uber and not the opposite. The last thing I wanted to stress today is the fact that law and economics, and the reason why law and economics is important for lawyer or is important for would-be lawyer, is that you're going to recognize that, yeah, we are having legal rules. But what matters are not just the legal rules. What matters are the real world consequences. This is what is important. And as a lawyer, you need to understand that this is what is important. Okay? The law is just a tool. And I need to use that tool to obtain what I want. And that is all. Okay? So, do you have any question? Or was it clear, not clear? Okay. I try to finish sufficiently in advance so that you could have the possibility to ask some question.
So there's a slight lag in receiving questions, so we can maybe take that at the end of the session. Meanwhile, I request all participants to post their questions if they have any. Or if anybody wants to speak, please, you can turn on your cameras and you can unmute yourself and you can ask questions.
Okay. So no question.
Sir, I haven't received any. I mean, there's a slight lag we get with the chat box. So,
And actually, everybody is probably tired also.
okay, sir, we have received a question for you. That is by Ms. Jyoti. She is asking, sir, as far as public policy is considered, how do you think economics can help in addressing questions from public policy?
In many, many ways. Because if you're looking at public policy, in general, you're going to say a few things. The economics could be relevant to tell you when it's relevant to intervene. And as you know, there is a narrative in economics that is saying that you need to intervene whenever, or it could make sense to intervene whenever there is a market failure, but then you need to think about the market failure. Economics also help you because it identifies different regulatory strategies. So typically, you're talking about command and control and economic incentives. And economics could help you to think about these different tools. For example, with economics, I can prove that the incentive to innovate are way higher when we are using economics incentive and, for example, taxation mechanism, than if I'm using a standard, any form of pollution standard. Economics will be relevant regarding question of public policy because I will understand also that there are some things that are called government failure. And if I'm not taking into account this government failure, it will be very difficult to try to design a system and an institutional system in which, for example, it will be possible to lower the risks of capture of a regulation. Law and economy could be relevant at many, many levels. And actually, this is my field. So what I am doing is mostly doing regulation, and I'm teaching regulation and public policy. And these are exactly the type of question that I'm addressing. So hopefully I will translate my book that will be published in French this year, and hopefully it will be translated in English in the next 2 years. So you will have all my answers regarding that.
Hello, sir. So, actually, I'm writing a
Yeah.
paper on decriminalization of cannabis in India. So, I was hoping for some economic tools
Yes.
if you could suggest for making the point that regulation is better than a total ban on the consumption of cannabis.
So on that, you have many, many possibilities. Okay. So first thing that I would say is, why are we regulating cannabis? You could regulate cannabis because of some form of morality and moral reason. Okay. Economics in general, they do not like morality reasons because that's something that is very difficult to understand. They prefer to say that the reason why I will try to regulate cannabis is because I'm considering that there is some form of a negative externality that is being generated by it, okay? If I'm considering that there is a negative externality, what is the best solution? And as you know, some countries decided to legalize it fully. If you are going to the Netherlands, for example, if you are going to Portugal, it's fully legalized, okay? But then you will have certain control and all those things. The traditional reasoning for an economist would be to say, okay, if there is a negative externality, then you could still have a market, just control who is going to access that market. Because otherwise, people will find what they want, but because they will use the black market, the prices will be higher, the quality will be lower, and at the end, sometimes it could be quite problematic. Okay?
Yes, sir. That answers my question. Thank you.
So we have another question for you. That is, if market fails to deliver efficient outcomes, then there is a rationale of government intervention and presence of externalities and provisioning of public goods. But what's done when government fails to deliver efficient outcomes?
So that's something that we're saying a lot regarding regulation. A lot of people are going to just focus on the market failure, and they are going to say if there are market failure, the government should intervene. Some other people are going to just focus on government failure, and they are going to say the government should never intervene. Okay? What Causes was saying, if you have read The Problem of Social Cost, is that what we need to do is to compare the different arrangements that we're having. Okay? And what I'm believing right now regarding these questions is that the only way to be sure to achieve what we want to achieve through regulation is to design an institutional system in which, because of this institutional system, the worst regulation could never be enacted. And that's the reason why we're having impact assessment, that's the reason why we're having a separation of powers, that's the reason why we are having most mechanism like protection of fundamental rights at the level of the Constitution and all. And that's really what I am believing. Did I answer the question? Yes, no?
Yes, sir. Yes, sir. We have just received her reply. I think it's a very fair point you made, sir.
Okay. So regarding regulation, I think that it was 3 years ago, I gave a certificate course on the economics of regulation, law and economics of regulation. So probably it will be possible for you to find the slides somewhere, or if you're not finding them, then I can provide you with some, like either good books on regulation from an economic point of view, or with some literature if you want to have some regarding that.
So that will be great if possible, if you could please share it with us.
No, that's, I have absolutely no issue on that. Like that's actually, that was my, that's my specialty. So just let me
Professor?
know what exactly you want, and I will provide you with all the literature you could, I will not say dream on, but I can provide quite a lot.
So I was specifically looking for how a regulation is better than banning something totally, if that could be possible.
So most economists are going to say it's better almost always not to ban, because banning is a command and control strategy. And this command and control strategy, what we are discovering is that most of the time you are going to have a black market that will occur. And most of the time also, and that's something that could interest you, check a paper that is called The Bootleggers and the Baptist Problem, in which you are going to say that drug dealers, for example, are going to be for a total ban of drugs. Why? Because then the price will be higher and they are going to control the market way more easily and less competition. So just use the analogy that you had with the prohibition in the US. So Baptist and bootleggers problem, and that was a Bruce Yandel paper. But just send me an email and I will send you everything.
Thank you so much, sir.
Any other question?
Yeah, I was wanting to ask you something.
Yes.
So you did mention the importance of, at least in some countries, China, Korea, as you mentioned, trust, the importance of trust. Trust more important than the law.
Yeah.
I was thinking in terms of, when things are getting way more digitalized and way more sophisticated and, more and more erosion of the human contact, between exchanges. How would this concept work, in this world that we are, we've almost entered into, would law then take the forefront compared to this basic construct of the trust and the human element?
Actually, some people could say exactly the opposite. Some people are going to say that, yeah, through this network and social network, yeah, we are not going to interact like directly face to face with other people, but we could create what has been called, for example, by Todd Anderson, a digital tribe. And this digital tribe, it's very easy to know about it. Like most of you, I'm assuming that when you are choosing a restaurant, you are using Yelp or you are using Zomato or you are using these shared experience platform because it is providing you with the type of trust that you need. And up to some point, you are going to learn how to read that. Okay, if you are using, for example, hotels, I think that's hotels.com, you are going to have the review. Under the review, they are going to say, okay, so you went in that hotel, but where you coming for your work? Where you coming for leisure? Where you coming for a family? Where you just a couple and all these things? And then you can have an idea of this of whether or not, like, what will be the quality of the service. If you are using eBay, that's the same thing. You will have a mechanism that will be just of rating the different people. Rating the different people, this is a way also to create trust. If I'm facing someone with, I don't know, 1,000 sales and he's having a 100% score, then I can trust that he's going to do his job. And I can use that for almost everything. And more, if we are using the platform and the different platform, Airbnb and all, it is also a way to create trust, which is something that is extremely important. And law is just one way to do it.
Yeah, so Professor, I see that part. I see the part of the magnified resonance, that comes through the, was that common sharing of experiences. But then there's another world also within that sphere, which is maybe not directly related to consumer satisfaction index. It might be a little more complicated. For example, I'm talking about the use of the digital resonance, in terms of there's a make-believe world also out there. Might not directly with the consumer satisfaction index, but let's say the citizen satisfaction index, if we take it another level. Yeah.
That's indeed another level. So on that, the problem is just that these technologies, despite the fact that we're used to use them, are relatively quite new. And what you are learning almost intuitively when you are using these technology and these websites, that you are going to learn how to use them. And if you are using them adequately, and if you are learning also, because there is a learning by doing part of it, I'm pretty sure that it can provide you with some good things. Then, of course, you have the problem of the fake news. Then, of course, you have the problem of whether or not your website is providing accurate information. But in that case, if I am the owner of the website, my incentive is to make sure that what is being posted on my website is accurate. Why? Because if it's not accurate, up to some point, the different citizens will stop using my website and they are going to a competitor's website. And that's not necessarily what I want. Or what they are going to do is that they are going to use many different websites in order to have an idea.
Reggie, would that be correct that would be correct for consumer consumption? Would that be correct for political consumption, especially when things can get cartelized?
So for political consumption, that's quite difficult, simply because the product that is being sold by politician is very different. And I would also say that for most people, when we're talking politics, they do not necessarily want to have something that is fairly rational. Okay, I could provide you with few example. Like I was surprised the first time I came in India, and because I was watching sometimes the TV, even if I was not understanding it. And if you are watching, for example, I think it's Republic TV, it was quite clear that, yeah, I do not want to share any idea. The thing that I want is like make some buzz or something like that. That will attract some people, but not all of them. And I'm pretty convinced that because of that, you had some other media which were created. Because of that, you had some other ways to share information. So there is also this idea of, once again, the market, and the market is going to evolve, and the product that I'm going to sell is going to evolve. So I'm not sure that it's possible fully to rely on these websites for that, because behind politics, you are having way more emotion. But if it were possible to make sure that, for example, everybody had the possibility to fully express their opinion on certain political leaders, then yeah, it would be possible, I'm assuming, to have something that is sufficiently adequate.
Right. Thank you. Thanks, Professor.
Any other question?
Shubi, if you don't have a question, please take over, and we can thank Professor Reggie and conclude his session.
Yes, ma'am. I don't think we have any questions. However, people have asked you for your. Okay, we have one question from Miss Chitra. She is asking. She's asking you to suggest some readings on economics of regulation.
Okay, so I will use a chat and I will give you a few stuff.
Thank you, sir. And thank you for your session. We also have Youth Kamer sir now with us. Good afternoon, sir. And it's a pleasure to see you again. And I'm making you the presenter, so you should be able to share your slides.
Are you talking to me?
Yes, sir.
Hi. Hi. Yeah, it's a pleasure to be here. But when should I start now?
Yes, so we can commence with your session. You should, you can be, maybe if you try to share your slides, you'll be able to do that now.
Okay, so let's do this. Share. What is screen one? Okay. So tell me if this works.
Yes, sir.
Works? Okay, so
Yes,
now.
yes, sir.
And now?
Yes, sir. We are able to see your slides now.
Terrific. Okay, so it's good afternoon, right? What time is it in
Sir, it's
in your...
6. Just a second, sir.
Professor
Let me.
Ehud, Professor Ehud, it is 6 evening in India.
wow, so it's good evening then.
Yes.
Okay, so I guess I'm then. Go ahead.
I'm Ranita, and nice to see you.
Hi, nice to hear you. I can't see you yet. Would like to see you. Don't see you.
How have you been? Can you see it now?
No, because it's the shared slide screen, so I only see little icons on the side.
All right.
But I will see you later in the Q&A session, perhaps, when I turn off the sharing.
All right.
Okay, so thank you very much, Ranita, for inviting me, and thanks to everybody for staying for my lecture. Is this the last one before dinner?
Yes, sir. This is our last lecture.
Wow.
And before starting our lecture, I would like my student coordinator, Kushi, to please introduce her so that we know you better, sir.
Please.
I would like to extend a very warm welcome to Professor Ehud Kamar. He is currently a professor at the Faculty of Law at Tel Aviv University. Before joining the university, he was a professor of law and director of the University of Southern California's Business Law program, as well as a visiting professor at Harvard. He has taught subjects such as corporation, securities regulation, mergers and acquisitions, and other quantitative empirical methods and deal planning, and has published various articles in leading scholarly journals. In 2019, he has received the Fatted Prize for Excellence in Legal Research. His interests include corporate law, finance, mergers and acquisitions, law and economics, and an empirical analysis of law. It is quite a pleasure to welcome you here, sir. Please take it away.
Thank you very, very much for this gracious welcome, and I'm very happy to present in this distinguished forum, even though I can't be physically with you. At least we can share ideas thanks to the internet. So this is a joint work that I'm going to present with Professor Jared Elias from University of California, who's actually visiting this year. He's going to start this year visiting at Harvard University, and Dr. Kobe Castiel from Tel Aviv University, my colleague, whose office is right next to mine. So I'm told that I have a full hour, and it's supposed to be 50 minutes talking and then 10 minutes for Q&A. But in fact, I think I can finish my presentation a lot before that and leave more time for questions. This paper is extremely simple. Yeah, and it talks about a new development. When I say new, I mean it's something that is developing in the last less than 10 years in the United States. And it pertains to companies that are in financial distress and are entering into a Chapter 11 bankruptcy in the bankruptcy court. Let's see what happens to those companies. So the motivation is as follows. So in a normal corporation, a healthy corporation that can pay its debt, you would have the board of directors in charge of the management. And quite often you will find on the board of directors so-called independent directors. These directors are not related to the company as insiders. They are not officers. If the company has a controlling shareholder, they're supposed to be also independent from that shareholder. So they're not supposed to be employees or affiliates of that shareholder. And oftentimes when the company makes decisions and when the board makes decisions that have an element of potential conflict of interest, for example, related party transactions or handling shareholder litigation against company insiders, the courts will typically pay deference to these independent directors because they are supposed to be objective, neutral, even though they are on the board of directors, they are part of the board. The way they were appointed and selected in a way that is supposed, at least in principle, in theory, to ensure that they are independent, that they are not beholden to either the company's CEO, the company's management, or if there is a controlling shareholder, the company's shareholder. Now, I'm a little skeptical about their ability to be as independent as they claim, but that's a different story. Now we're talking in this specific presentation, we're talking about a company that enters the world of bankruptcy. So this is a company that reaches a stage of insolvency. It cannot pay its debt. And then at some point, it decides to file for Chapter 11 protection from its creditors. And what you will see is that this corporation will oftentimes, when I say oftentimes, I say this is something that has developed in the last 5-7 years or so. This is a recent development. The board of directors will have to appear before the bankruptcy court. Typically, the court will appoint a committee of unsecured creditors. These are the creditors that are last in line for receiving their debt payment, so they are not protected by any lien on assets. So they are probably the last ones to receive any money, and so obviously they are the most vulnerable. Now, typically the court will listen to this committee of unsecured creditors and will see this committee as a representative of those directors, of those creditors' interest. However, what we see in the last few years is that the company, several months before filing for bankruptcy, it will appoint new directors, typically 2 of them, to the board of directors. So these are new directors that were not on the board of directors all along. And within 6 months or so before filing for Chapter 11, it will appoint these directors. Who appoints these directors? The board appoints these directors, adds them to the board. And once they are on the board, the board will appoint them and will tell them, look, we want you to make decisions for the board in the course of this Chapter 11. Before the Chapter 11 proceedings begin, these directors will form their own committee of those 2 directors that will investigate, that will look into the history of what triggered the insolvency. What happened? What went wrong? Why did the company go south in the sense that it could not pay its debt? And once this company files for Chapter 11, these directors, the independent directors, will go before the court and will say, Judge, you can trust our judgment because we are independent. And in fact, we have conducted our own investigation of what happened. And we would like to help the court to handle this bankruptcy so that the company will be able to emerge from bankruptcy as fast as possible without any employees losing their jobs, or at least minimizing the number of employees losing their jobs, and so on and so forth. In this case, the court quite often will heed the recommendations of this committee of independent directors and will say, okay, if you are neutral, if you're objective, then you can help me handle this case. The problem is that, it is not so clear that these independent directors by name are also independent by in effect. And the reason for that is very simple, because it's the company, and specifically the board of directors, which is controlled by the shareholders. The shareholders are the ones who appointed the board. They are the ones who select the independent directors. And as a result, it's not so clear that they are independent. So let's look at the trend. So what you will see here is a diagram showing what happened in the last few years. So you see that if we are looking for the proportion of Chapter 11 cases, that is, each case is a company, where the board says we have at least one director who is independent, you will see that it increases over time, so that if in 2009, less than 5% of the companies in bankruptcy claimed they had this at least one director who's independent, today we have over 40% of the companies saying this. Now, we looked in our study on Chapter 11 companies with assets and or liabilities that exceed $250 million. So these are large bankruptcies. We have over 500 of them. And so you can see that there are more companies that say where they have independent directors. Now, what I would like to do in this short presentation is give you one motivating example from a recent bankruptcy of a luxury goods store called Neiman Marcus. Then I will tell you a little bit about our sample, because our research is designed as first a case study, a couple of case studies. One is Neiman Marcus. Then we have some empirical analysis. Then I'm going to look at independent directors and what specifically they do on the board of directors once they are appointed. Then we'll talk about the potential conflicts that they have and how the law does not deal with them. And then I'll offer some suggestions how we can fix the problem. Okay, so what happened in Neiman Marcus? So this is a company that is controlled by a private equity sponsor. So it owed $5 billion to creditors. There was a cause of action. So these creditors could sue and say there were all sorts of wrong things that were done before the company went bankrupt. And it's worth about $1 billion. So that's the potential litigation exposure of this private equity fund. Now, the court appoints an official committee of unsecured creditors. However, the company also appointed its own independent directors. There were two of them. One was a former lawyer. The other was a former investment banker. And look what happens. Once they are appointed, they investigate what happened in the case. And what we see in the case is that there were two competing investigations going on roughly at the same time. One by the independent directors, those two guys, and the other by the Committee of Unsecured Creditors. Now, the official Committee of Unsecured Creditors obviously cares the most about creditor interest. It is appointed by the bankruptcy court. Its source of authority is the bankruptcy code. It's the statute. What about the independent directors? Well, that's an invention. It doesn't exist in the code. It's the board that, of its own volition, decided to appoint them. And it's the same board that's controlled by the private equity fund that is going to be the defendant in any creditor litigation. There is no source of authority for this committee of independent directors, only their claim for disinterestedness. And when the court appoints this official committee of unsecured creditors, it is responsible for holding a hearing to make sure that there are no conflicts of interest of this committee, that this committee is properly set up, and so on. There is nothing in the bankruptcy court about the independent directors, and as a result, nobody actually checks what kind of conflicts exist. And here is the interesting part. The Committee of Unsecured Creditors concluded that the creditors could sue the private equity fund for about $1 billion. What about the independent directors? They concluded that the litigation is worth much less, and ultimately they settled for $172 million. Now, in order to settle the case, they had to get the agreement of the creditors, but the creditors were in a bind because the independent directors had a lot of influence on the court, and they created a dynamic in which it was very clear that there was not much maneuvering, not much negotiation room for the creditors. In other words, the creditors claimed that the independent directors, by name, actually sabotaged their claim. Now, this is what the Unsecured Creditors Committee position was. This is a quote from the court hearing. And the lawyer for that committee says, I think the system was rigged against the unsecured creditors vis-a-vis the settlement process. And he continues, why should you, and when he says why should you, he means why should the board, why should the company, why should the private equity fund talk to the committee who's really representing the interests of the unsecured creditors, when you in fact can go ahead and just talk to the independent director, who is effectively going to sell out the unsecured creditors. So that's what the creditors believed in that case. Now, the fact that they believe this doesn't make it true, and our research is supposed to check this claim to see who's right about this. So how do we go about doing this? We have put together a very large sample, in fact, the largest ever sample of bankruptcy cases that was ever assembled by researchers. So ultimately, we start from a larger sample, but in order to get all of the variables we need, we narrow it down to about 450 firms that filed for Chapter 11 between 2004, 2009, and filed a document called a disclosure statement with the court. This is something you file before you complete the bankruptcy and you pay out whatever is paid out to the creditors. This document is very informative, and we find in this document, it's very thick also, it has many pages. We find a lot of information that we need for our study. Now, altogether, we have a little over 2,500 directors. Most of them serve only once in our sample, but 78 served on 2 boards, and then 12 served on more than 2 boards within our sample. We also gather the job history and other data for each director from another data set called BoardX. And we get that for a little over 2,000 unique individuals. When I say unique individuals, keep in mind that some directors serve on more than one board. So either in different times in their history or at the same time. Then we ran using a computer a word search on all these court documents, those disclosure statements, in order to identify first cases where there are independent directors, and then once we found those cases, to see exactly what they did in those cases. So here is some summary statistics, so you will get an idea of what our data look like. Here. So you see 3 categories here: financial characteristics of the bankruptcy, bankruptcy characteristics, so what happened in the bankruptcy case, and then board characteristics. Then we compare 2 types of companies: the ones that had appointed bankruptcy directors. When we say bankruptcy directors, these are directors who claim to be independent, who are appointed either shortly before or shortly after the filing for bankruptcy. So these are the so-called independent directors. We call them bankruptcy directors because they're appointed specifically for handling this bankruptcy. And then we compare that group of companies to the companies without bankruptcy directors. And what quickly stands out here, what happened? Thought it worked, but it didn't. Oh, what clearly stands out is so in most cases, in most respects, these 2 groups of companies are similar, but there are some clear differences. First, we see that the companies who have bankruptcy directors, who appoint independent directors shortly before the bankruptcy, tend to be controlled by private equity funds. Okay, and you see that the difference between them and the other group of companies is significant at the 5% level. Then we see that companies that appoint independent directors before the bankruptcy are likely to have a controlling shareholder. Keep in mind, when I say companies in this sample, some of the companies don't have any public equity. That is, they're not publicly traded. They're private companies. They have only one shareholder. But we also have companies that are publicly traded, and we see that when they are publicly traded, they have a controlling shareholder. In fact, you see that the companies that are publicly traded are less likely, although it's not significant, less likely to appoint independent directors. Now, another interesting fact is who's representing these companies. And it's very easy to see that there are 2 law firms that are more likely to be representing the firms that appoint independent directors shortly before the bankruptcy: Kirkland Ellis and Weil Gotshal. Now, that's not surprising because these are leading law firms handling, representing debtors, large debtors in bankruptcies. So if this is a sophisticated recent development in representing debtors in Chapter 11 bankruptcies, you would expect leading law firms to be pioneering this practice. Finally, you see that companies that appoint bankruptcy directors are more likely to have at least one director who is a lawyer and at least one director who already has experience in Chapter 11 bankruptcies. As we will see later, it's this bankruptcy director, that independent director, who tends to be a lawyer and with Chapter 11 experience. Okay, so now when you look at the portion of Chapter 11 boards with some director, at least one director, who has experience in Chapter 11, you see that that number or that percentage increases over time. That is, today, in 2021, you are more likely to have a director on the board of a Chapter 11 firm in this sample, $250 million or more, that already was on the board of another company that filed for Chapter 11. So today you will see boards of Chapter 11 firms they are more likely to have experience in handling bankruptcy because they served on a board of a bankruptcy firm before. How do I? Oh. This figure is quite similar, but here what we see is the portion of Chapter 11 firms that have at least one director who claims to be independent and who was appointed shortly before or shortly after the bankruptcy. So essentially, the similarity between this figure and this figure shows you that it's the same people. It's the companies who appoint independent directors. They specifically appoint independent directors with bankruptcy experience. Now, who are these people? So about half of them have expertise in bankruptcy. Quite a few of them are lawyers. Even a larger percentage are investment bankers, and some of them have experience as traders of distressed debt, that is, debt of companies that are in financial distress. So these are investors who specialize in companies in financial distress. Obviously, this debt is going to be cheap. They're going to buy it and hope that things will improve for the company, or they will make money of this. So people with this experience, they are also more likely to be independent directors of companies in distress. Now, what do they do once they are on the board? Well, one thing they do is evaluate restructuring proposals, negotiate with creditors, run sale process. About 70% of them, that's what they do. In 70% of the cases, 73% of the cases, we see that they say they do that. In other cases, they investigate claims against pre-bankruptcy shareholders. Almost half of the bankruptcy directors do this. So that's another activity that's quite common. They may also investigate claims against lenders, against creditors. In a small percentage of the cases, 16%. And then finally, if you put together the investigation of both pre-bankruptcy shareholders or creditors, you will get obviously a larger percentage, 46%. So these are all investigations of potential claims of fraudulent transfer, fraudulent conveyance, all of those claims that you will see being filed in a bankruptcy court. Now, the first category, evaluating restructuring proposals, negotiating with creditors, running sale process, all of this sounds quite good. It sounds like it makes sense that people with bankruptcy experience will handle these issues for the board. So you bring an expert. You're now in bankruptcy. and now you need somebody to help you, you bring someone with experience. Okay, that makes sense. However, the rest of those activities are potentially problematic. Why are they problematic? Because the same people who appoint you to the job are the potential defendants in these kind of lawsuits. So it's the shareholders who are going to be sued for fraudulent transfer, fraudulent conveyance. Also, potential creditors can be sued. So what, and this perhaps is the most, I guess, interesting result that the paper shows. So far, I explained to you that there is a practice that seems to be problematic. We have directors who claim to be independent, but they don't look so independent because they were handpicked, they were selected specifically by the very same people who are going to be defendants in the lawsuit. So why would we trust the selection of these people? So there is a potential bias, a structural bias in favor of the controlling shareholders by these directors. And the table that you see before you now shows the result of some regression analysis. And so we have several regression models, and they all lead to the same conclusion. Right? So what you see here is that controlling for other factors that might affect how much money the unsecured creditors get in the bankruptcy, we see that the fact that the company appointed a bankruptcy director, that is a director who claims to be independent and was appointed shortly before or after filing for bankruptcy, the fact that the company appointed that person means that the unsecured creditors at the end of the bankruptcy proceeding, they're going to receive less money. How much less? On average, 21% less. That's a lot of money less in the cases where the supposedly independent directors are appointed. Now, obviously, this doesn't show causation. It doesn't show a causal link. That is, this is no proof that the independent directors are the reason for the lower payment to the unsecured creditors, but at least we see correlation here. And the way we see it, at least it shifts the burden of proof or the burden of providing evidence to anyone who claims that these directors are not the reason for receiving lower payout. Keep in mind that when we look at specific cases, I mean, I told you before about the Neiman Marcus case, you can see specifically how those independent directors deflate the claims of the creditors. They say, this is no big deal. And they seem to be unhelpful to the creditors. But obviously, these are just specific cases, and you could always argue, well, the companies appoint these kind of directors in cases where the payout to creditors would have been lower anyway. It's not their fault. It's just that these are the harder cases. It's just that we, as researchers, can't see why this is the case. We find no difference statistically between the cases. We just see that these directors are associated with lower payment to the unsecured creditors. Now, there is also interesting evidence of concentration. So it turns out that these independent directors make a living off going from one bankrupt company to another. And there are some of them. We identified 14. Here you see 8, but in our entire research, we find 14 You find them time and again going from one company to another, just like a butterfly moving from one flower to another. They always come for this bankruptcy and then they move on to the next company. Why is this important? It's important because if someone is financially dependent on income from serving as independent director on bankruptcy boards, obviously that person will have at least the temptation to be nice to the shareholders who hand him the job or her the job. In our sample, by the way, these are all men. In other words, whenever you serve as an independent director on the board of company A or X, you always say, if I conclude that the lawsuits against the controlling shareholders and so on are actually justified, it's not going to make me attractive for the next case. No one will want to hire me because I'm bad news for the shareholders. So here is an example from the website of one of the individuals that we see a lot in our data. And he actually brags and says, well, look at me, I'm very experienced. I was on the board of company X and Y and Z. Of course, this means that he wants to maintain a reputation of being useful to those companies. Now, when you look at the concentration in the market for legal representation, so you see of all debtors in our sample, Weil, Gottschall, and Kirkland Ellis, these are leading law firms representing debtors. And you see that they have, 20% of the of all the bankruptcies in our sample, even more than 20%, belong to them. But then when you look at the cases where there is a repeater, someone who goes to the same, who has bankruptcy experience, you see more representation for Weil, Gottschall. And when we look at cases where we actually can tell the names of independent directors, again, you see even more representation. And in the cases where independent directors investigated claims against insiders, you see that over 40% of the cases are clients of Kirkland Ellis, and I can't measure it here, but a large portion of the cases are clients of Weil, Gottschall. So what are the potential conflicts? Well, obviously, you want to be nice to the shareholders who hire you, and the law firms are the same law firms. So these law firm that today represents client A, tomorrow will represent client B, and you don't want to disappoint them, right? Because you want to get a phone call saying, would you like to help us with client B? So what do we make of all this? Because we are not just empiricists, we are law professors, and we care about legal reform. So we think it's hard to justify giving this immense power and influence to directors in Chapter 11 when these directors are not elected by the creditors. This is very different from corporate law. Maybe in corporate law, we are used to relying on independent directors, but at least there, the shareholders run the show and the shareholders appoint those directors. But here, the shareholders appoint the directors. The law is not supposed to protect the shareholders, it's supposed to protect the creditors because the company is insolvent. So we're not saying that they're useless. They do contribute expertise. But even if we want to benefit from the expertise, the law and the courts should still police their potential conflicts of interest. So we think that the bankruptcy court should be very careful in scrutinizing their conflicts of interest. And especially this should be the case when there are claims against the insiders that they transferred money improperly before the bankruptcy. And specifically, when the Unsecured Creditors Committee, that's the UCC, when it objects to the identity of the independent directors and say, we don't want these people, the court should be very suspicious. The court should be very careful because there may be a good reason for the creditors to object. And if the Committee of Unsecured Creditors wants to prosecute claims, then the court should listen to that committee and not say, oh, the independent directors said there's no point in investigating, so I'm not going to let you investigate. So the conclusion, the new data that we provide show that independent directors are major new players in this in the Chapter 11 landscape in the last decade, and this is a major change. Why is it a major change? Because the bankruptcy court, the bankruptcy code anticipated a setup where the bankruptcy court handles the case. The bankruptcy court hears out the creditors and hears out the company and tries to find the justice in all this, to balance the interests of all those involved. And so there are checks and balances built into the bankruptcy code in order to make sure that the process moves forward. There are no checks and balances in the bankruptcy code to handle independent directors. It's a new development that doesn't exist in the bankruptcy code, and it basically circumvents, it goes around everything that the legislature had in mind. So we think this is problematic. What we think the bankruptcy judge should do is ask very early in the proceeding the unsecured creditors, how do you feel about these independent directors? Do you agree that they're independent or you have issue with them? If the if the unsecured creditors, or at least the critical mass of the unsecured creditors say, we don't trust these guys, we don't like their selection, then the court shouldn't treat these independent directors as independent. It should say, okay, these are directors, they may be right in what they say, I should listen to them, but I shouldn't assume that they're independent. Rather, I should assume that they're partisan, that they represent the debtor, not that they're not some neutral trustee that's supposed to be objective. One last point here. Oftentimes, when we have issues with conflicts of interest, the law's solution is disclosure. Let's disclose everything and everything will sort itself out. Well, no, this is not going to be a sufficient solution. Obviously, disclosure is useful here. And obviously, the court should demand that the company disclose the potential conflicts of interest of these independent directors. For example, we should know, everybody should know, how many times they worked with the same law firm that represents the debtor. How many times did they work representing on the board of bankruptcy boards? What companies were they? What happened in those bankruptcies? Everybody should know that. So transparency is important, but it's not enough. Because if we just demand disclosure and we do not listen to the unsecured creditors' objections, then we will basically legitimize and get used to a problematic practice, and it will just become part of the bankruptcy routine. This is not what we want. So that's my presentation. Now, how do I turn this off? Stop sharing. That's it. What should I do next?
So for questions, there's a slight lag in the chat box, so I think we need to wait for a bit. Meanwhile, if anyone wants to unmute themselves and speak, please feel free to do so. Thank you.
Good evening, Professor Revut Kamaria.
Should I look at the chat box? Are there questions there?
So there's a slight lag in receiving questions.
Good evening, Professor Kamar. Am I audible?
Some questions are coming privately to my chat box, so I'll read them out for you. But
Okay.
yes, the questions are coming on chat box and also in Q&A section. Just next to chat box, you should see 3 dots. If you click on that, you're able to see the Q&A part.
Next to the chat box, there is what?
There are 3 dots. You can see
Yes.
participants chat and 3 dots. If you click on that 3 dots, you'll
Yeah,
be
I
able to
see
see
Q&A.
Q&A.
Yeah.
Yes. So there's a slight lag in receiving questions here.
Okay. So
Can
I
you move?
see.
Can I ask
Yes,
one
so
question, Professor Kamar?
Sure, from at least, yeah.
Yeah.
I mean, whatever. Yeah.
Yeah, Hitesh Thakkar, sir. Good evening, sir. I hope
Good
we
evening.
met in Pune, if you recall, the Gokhale
Yes,
conference.
I do recall, of course.
Yeah.
Yes,
Sir,
how are you? Good
I'm
to hear
fine.
you.
I'm fine, sir. How are you, sir?
I'm wonderful. Thank you.
Sir, with regard to how to, I still don't understand. Your results do provide the a very critical side of the bankruptcy where people do get some influential benefit. But how to balance? Because same happened in the Indian case also. I am also doing same research in insolvency law in India. But how to make balance between and provide that all people have a they have a win-win situation here. That I think it's still not possible. In fact, I find your result may be better if you get same data from Indian context. You will find a different level of interference and that part. So I don't know how to get that trade-off. I don't understand still now. If you can just put some light on that.
But okay, but I want to make sure that I understand. So you see the conflict that we describe, and you disagree with our solution, with our recommendations, or with our findings?
I go with your finding, but still, despite of that, still that will be there because you can't make everybody win-win in the game of insolvency.
Okay. So we do not claim that companies should be prohibited from appointing these directors. We have no problem with appointing these directors. The only thing we say is that if the company wants the court to treat the directors it appointed as independent, the company should make sure that it selects directors that creditors will later support. Now, practically, it's not easy because suppose that the company appoints the directors in January and then files for bankruptcy in May. So it's not easy to appoint directors in January that only in May, 5 months down the road, the creditors will support, and you don't want to talk to these creditors perhaps already in January because you don't want to tell them you're worried about bankruptcy. That's not easy, but one solution is to appoint directors that serve the creditors well in previous cases. And so later the creditors will say, oh yeah, I trust them because, you know, because I've seen their record and it seems like they are balanced. I don't know if it answers your question, but you can ask me another question.
No, it's great, sir. I will send you some Indian data and you can just check it how far your US study versus Indian study, how it's different. I will send you
I
some.
invite you to conduct the Indian study. For me, we want to get this one done and published.
Yeah.
That will be enough for us.
Yeah.
Any more questions? Should I answer?
So I haven't received any question as of now.
Yeah. Well, nobody's turning on their cameras. Why? You don't have cameras? Oh, now I see you. Yeah. So
I'm not
who's
well, so that's why I put my camera off.
No, it makes it 100 times better. It makes it real for me, you know?
Mm-hmm. That's a great work. If you can just send your PPT material, we can circulate to the participants.
The PPT, it changes all the time. But I can send a paper. Oh, I have to show you something. Hold on.
Yes,
Let me show you something. Yeah, I gotta do this. I'll do this just quickly. We had this. Where is this? Share. I want to share with you this with you. See? They wrote an article about this in the Wall Street Journal about our paper. You see? But they didn't mention the names. They just said researchers. So, but that's I can send you the article if you like. Okay, now I have to turn this sharing off. Yeah. Shubhi, I rely on you. You will tell me what questions to answer because I'm new to this platform.
Any questions. I think they are all very satisfied with your presentation.
They're just hungry. They are tired and want to go home. It's a long day, right? It's already 7. What time is it there?
Yes, it will be 7 in 5 minutes.
Okay, so yeah, so that explains everything.
But it was so nice having you, sir, finally with us.
Thank you. Yeah, it's my pleasure. It's here. You know, this is Friday. They closed the building, the university building. But I asked the person who handles the building to keep the air conditioning working today just for me because it's so hot. It's unbelievably hot here in Tel Aviv. And it's hot and humid. And you just stand and you sweat. It's unbelievable. So
we can relate with you, sir. We live in India, and that too in Gujarat. We can absolutely relate.
In
Sir,
Gujarat, it's humid or dry?
it is pretty dry, but it gets humid as well.
I see. Well, I
Um,
should come to visit at some point.
Yes, sir, definitely. It would be a pleasure having you over.
Yeah, it will be my pleasure.
And sir, the participants have very kindly asked you for your email and they are thanking you. Okay, so I've received a lot of thank you messages now. And
Sure,
they have
thank you
asked,
very much. It's really a great honor to be in this forum, and I miss you guys. I remember meeting in Pune, and it was fun. And I look forward to the next conference.
Sure,
yes,
sir. Sure, sure.
hopefully things will get better by then, and then we'll be able to host you in our university.
Excellent. So should I stop here now?
Yes, sir.
Yeah.
Yes, sir.
All right. Thank you very much, and have a great
Thank you so
weekend.
much.
And until next time.
Yes, sir, indeed.
Bye-bye.
Bye, sir. Thank you so much.
So, Subhi, am I audible?
Yes, sir. Yes, sir.
So we can get feedback from participant, informal feedback, and then we can
Yes, sir.
conclude the 5 days workshop. And
Yes, sir.
and I think we have to remind that if they have not submitted the abstract, they has to. Otherwise, they will not. They are not entitled for completion of course. So just
Okay,
and just
sir.
give vote of thanks formally. Okay. Just first take
Yes.
informal feedback. So we invite all of you. If you can unmute yourself and one by one, if you want to give any informal feedback.
Yes, sir. So I request all participants to please turn on your cameras so that we can see you. And if you have any feedbacks for us, please feel free to share the same. And it was a pleasure having all of you for for all these 5 days. It's been an immense pleasure, and I had such a good time taking your questions and putting it across. There are so many people that I see, Miss Jyoti, Miss Preeti, Shailja ma'am, Ronak sir, I see so many people, Tripti. I have taken all your questions and it was such a pleasure. If you could just turn on your cameras and if you can just give us a few feedback, that would be great. I know we have all had a long day, but it would be very nice and I would personally feel very, very good hearing all of you. Thank you.
I think it was a great workshop. We had a lot to learn from everybody. And I think, Shubhi, you were great. You were taking all the questions as and when they were coming, although there was a huge time gaps between the questions. Then also you were managing, you were very sweet throughout. And I think it was a great session, a great learning experience for all of us.
Thank you so much.
If anybody can suggest something for further improvement, that will be great.
And I'll also be sharing a formal feedback form. And just to inform, we have a small assignment. You need to submit a small assignment to us. It is just an abstract that you have to submit. We will help you improve it further into a blog and to develop it into a blog. We'll be coming out fortnightly with our blogs. So maybe we can help and we can develop it further. So it's just a small idea that you have to put across. And I have already shared the guidelines with you. It is mandatory to submit it, unfortunately, but I hope you all submit and I hope you all take it forward. So this is just a request that please send it across whenever possible, either today or tomorrow. We are still accepting the assignments. I will keep the link open. If you are unable to use the link, you can even send it as an email to me, and I will be happy to upload it.
I had a question pertaining to the same. The abstracts
Yes.
which we will be sending to you, will they be considered for the GNLU essay competition that was also notified?
No, the essay competition is different and this is different. So this we can develop it into a blog and we can put it in the GNLU blog, and the essay competition is entirely different.
But you
All
can
right.
develop, Jyoti, you can later on develop that
Yes,
abstract
yes,
you can submit for the essay competition.
yes.
All right, sir. Thank you, sir.
Hello, Shubhi. Am I audible?
Yes, ma'am.
Thank you for the organizers for this workshop. So I think it
So
was
good
like,
to see you, ma'am. Thank you.
thank you for organizing, because I know it takes a lot of hard work and coordination and everything to bring such a learning platform together, right? So a lot of interesting ideas have come up, and I think I've also given a feedback. And I think you'll be getting the abstract by tomorrow at least. So
Thank
it
you,
was
ma'am. Thank you so much.
listening to everything. So maybe need some time to just bring it up. But thank you to everybody. So a
Thank
lot
you,
of
ma'am.
interest. So, because somebody was asking for suggestion, I work on international taxation, right? So maybe in the coming workshops, more speakers who can speak on the interface of tax and law would be great to have them, you know. So that will be a more of a learning experience. So that's the only request which is there. Otherwise, it was a great workshop and a lot of ideas and a lot of food for thought for to take my research forward in my own personal area. Thank you so much.
Next time
Thank you,
we
ma'am.
can invite you, madam, because you are working in taxation. And now you know law and economics. So it will be great to you can come to and you can share your idea.
My area of research is like the taxation of the digital economy, and that's the abstract is also going to be on that only. So it's going to come.
We look forward to your abstract, ma'am.
Thank you.
Thank you. Mr. Ashish has written, thanks for today's session. The workshop was quite enriching. Thank you, sir.
I have a suggestion as well, if it could be incorporated. I thought that the number of sessions per day was a lot. I think if the number of lectures could have been reduced and there could have been an increase in the time intervals between the sessions, because that would have ensured a little bit of break in between, and also the grasping of concepts, like 6 concepts in a day, would have been reduced to 4 concepts a day, so that if possible.
Thank you so much. We'll take that into consideration. I will certainly take that into consideration. Managing 6 workshops in a day was quite hectic. Yes, I agree. Thank you so much for your feedback, ma'am.
Hello, am I audible?
Yes, ma'am.
Actually, it was a very amazing workshop for me. I have got to know a lot about many topics that I had no idea. For instance, environment, law, and economics connection. So thank you for the workshop. And also, I agree with Jyoti. So it was kind of a long day for us because there were no breaks. So that was one thing. Otherwise, it was very good. Thank you so much.
Thank you so much, ma'am. I have received a lot of thank you messages on my chat box. Thank you so much. And it feels so great that we could help you in some way and put across something that is so new. And I'm absolutely grateful for all your messages. Thank you so much.
Susie, can you tell them something about CLE and our journal?
Yes, sir, but you would be the better person to speak. I have just joined the center. So
I'm not well. If I'll speak, I'm not. It's
indeed,
not.
sir. Indeed,
Yeah.
sir. But I will try to do justice. Center for Law and Economics. It is developed by Mr. Hitesh Thakkar sir and Ranitha madam. Ranitha madam is, um, I mean, this is her domain, and she has come up with this subject in our university. She has helped us develop this subject, and so Center for Law and Economics, we basically focus on understanding how law works in terms of economics, and we also help train students in the field of economic, and we help them understand the economic analysis of law. The center, it recognizes the values and works in the discipline, in this discipline, and it aims to promote the awareness of these two subjects. I mean, we live in a world where interdisciplinary study of a subject is very important, and this is what this center stands for. The economic analysis of any comparative or contemporary legal issue is very important to understand the subject, and it aims to produce quality research and prescription for legislator, regulators, and the government departments. We have a lot of research work going on in this, and since I am absolutely new to the center, I am still to understand and come to terms with it. Maybe in the next workshop, I'll be able to brief you better about it, but I know there is a lot of research work going on. And Center of Law and Economics has always tried to reach out to the bright young minds like you all, to like all our participants who have a keen interest in employing and understanding economic tools and theories in legal analysis. So and some of these little efforts can be seen in our center, and we have a very robust student committee as well, and we work on this subject and on these two fields. Thank you. Sir, did I do some justice?
Yeah, you just tell about our journal.
Yes, sir. We also have a journal, and we also have blogs. So we accept papers, and we also accept blog posts. We'll be coming out blog post fortnightly now. And for papers, we are currently not accepting papers, but we'll begin it shortly. As of now, we have an essay competition that is going on. You may submit your essays, and the same will be posted in our website. I will share the links of our journal and blog with you. You may access it, and you may see our research in the field there.
Can conclude it, Kushi?
Yes, sir. Khushi, can you please conclude? Thank you for all your messages.
Yes, sir. But, sir, I think before we conclude, would you like to say a few words at the conclusion of this session? I know you're not well, but few words to our attendees. Hitesh, sir.
I think it's an honest effort of Center for Law and Economics members, including the student members. Not ongoing, but already the people who are working from the past. I think because of that, I think we made the center as an intellectual hub in the India. And Subi has told about Center for Law and Economics Journal. I think I'm just happy to say that it's now considered for the UGC CARE list also. So these are the efforts of our young brides, the brand ambassador of Center for Law and Economics, and I think we are privileged to work under the guidance of Professor Nagar and other team members. And I think this workshop is only the beginning. We are doing many things. So I think if we feel keep it in touch, then we can collaboratively do some work which may be more meaningful for you also. And maybe I think collaboratively we can go long. That's what we hope. With that note, I just hand it over to the Kusi. Please take over. Kusi.
Thank you so much, sir. So, as we are towards the very end of an intense 5-day workshop, I would like to thank all the resource persons and all of you, especially all of you attendees, for being here with us throughout these 5 days. It is only because of you guys that we have been able to conduct such workshops. I would like to thank both Ranita ma'am, Hitesh sir, and especially Shubhi ma'am for giving me this opportunity. And we really hope that you guys can be associated with us in the future, some way or the other, whether it is through the essay competition, journal submissions, or blog submissions. So all I can say towards the end is that law and economics is quite an emerging field, at least in our country, where it has not developed to its fullest potential. And we as a center are trying our best to put in efforts so more and more people know about such an interdisciplinary study. And I hope you all of you attendees, whatever you have learned from this workshop, you can put these things to use and help in the development of this field. Thank you so much, everyone, for being here, and we hope to see you soon again.
Thank you, Kushin. With this, we come to the end of the workshop. Thank you so much for joining us. Thank you.